I have the temporary family law order presented by Ms. Baldwin. I see it looks like you have a handful or more of objections there. So let's start with, looks like paragraph 6 in the temporary order. And the objection is that the provision should include the petitioner may not go to the aerial address absent express written approval or absent any conditions detailed in paragraph 7.
Correct, Judge. This was the case where I think Your Honor made it explicitly clear that what's good for one spouse is good for the other, despite some of the issues that were detailed during the initial hearing. My client was awarded that house on a temporary basis in aerial. Now, the wife was awarded the Lone Oak residence with the provision that neither basically went to the residence of the other without express notice. We're just asking that provision essentially read mutual. Thus my proposed language in my objection.
And so if you look at paragraph 6 up around line 12, it's clear that he has sole possession of that property. And then if you look at section 7 down in the maintenance section, we had talked about that a little bit during the hearing. And we talked about specifically if she had to access the home, if it was an emergency, she would just send notification. So I think that this is really already taken care of with how the language is worded.
Arguably, I would agree with Ms. Baldwin, but I'm going to add that petitioner shall, just to the line after respondent has sole possession of the Woodland Park Lane address, petitioner may not go to that address absent express written text or email approval.
Very well.
And then if you just add or paragraph 7 below, because there's some like, if it's a plumbing leak and he's not there sort of provisions where the court said she could go, but then would provide notice essentially contemporaneous.
Yeah, that's fine. This is the one where there was some discussion about that, but there wasn't any specific court order that I recall to monies that either spouse took out prior to us coming to court and very shortly after separation. I would rather just reserve that for a final outcome as opposed to putting language in the existing temporary order that may or may not have been what the court had intended to do. So I guess we need kind of your input on that, but I just assume that we leave that out and just reserve it for a final outcome.
And so for the court's reference, we're really looking at the bottom of page 3 and where it says initial funds. So, and I'm going to roll this argument in with counsel's second argument on paragraph 9, where my client says $10,000 a month is fine and his client wants $12,000 a month. So our initial motion included the parties essentially receiving some initial disbursement of cash. There's a lot of cash in this case. There's a lot of funds to go around. And so it's kind of to not starve either, was to give sort of not only monthly funds, but sort of a larger amount for them to use at their discretion. So we had put that as part of our initial motion, which I don't think was really objected to. So these aren't funds that have already been used. This is just sort of giving each of them sort of a pot in addition to their monthly funds, in addition to significant other funds that are in reserve for ultimate distribution. My client says $10,000 per month is plenty for each of them after all bills have been paid. Mr. wants 12. My client says give us each 10, give each of us $20,000 on top to sort of use at our discretion. So those things really balance themselves out as written. I think it still gives Mr. Zandy the money that he wants. It just gives it to him all at once instead of parsing it out $2,000 at a time per month. So I would argue as to sort of both Mr. Zandy's point nines as written, this really does what its client wants. It just gives each of them a larger pot to play with initially in addition to monthly funds that are reasonable.
And we're consolidating issues there that I don't think is necessarily proper just yet. And the issue that we have with that verbiage again on page 3 states, and the respondent has received 17,000 via Red Canoe, he'll get an extra 3,000. Court certainly never made that finding. Furthermore, we haven't exchanged discovery, so we don't know what Miss Loffer has taken out of the accounts. Basically, she's saying, "Well, I'll take the 20, but I'm going to give him credit for 17 that he's already taken. Just take my word for it, wink, wink." And I'm not saying that did or didn't happen. I don't know. And that's why we need to exchange discovery to see what has happened on that. I'm fine if they both take a chunk of $20,000. I think that's appropriate. There's plenty of money to go around to do that. I just don't want to pigeonhole my client into a court order that says he's already taken 17 when we have no idea what Ms. Loffer has taken. So lead me to the next part of that, which again is under that same section, which is the difference between what the parties are asking to be taken every month. think everybody's agreed. Court wanted to treat apples to apples. And I said that whatever husband took or whatever wife took, husband was to take. And again, that was to be mutual. I think that was kind of the design throughout the court order. We're asking for 12. Ms. Lawfer is saying 10 for a couple $1,000s apart. And I'll leave that strictly up to the discretion of your honors to whatever you think is appropriate. And my client will certainly abide by that.
And I'll just clarify, we're not saying that he took the 17. In our initial motion, it was there's this account that has 17,000 and we're awarding that account to him, not that he's received it. So if counsel's more comfortable just saying they're each going to get $20,000 and not designating the account, that's fine too.
That's good, because the way the order reads, the respondent has received $17,000, and that's the part that needs. I don't know that is necessarily true or not.
All right. So what I've done is just lined out everything except for each party shall initially receive funds totaling $20,000.
That works.
Very well.
And then I'm going to leave 10,000 as appropriate. That's after I understand that the assets in this case are significant, but this is after everything is essentially paid. I think 10,000 a month is sufficient. And obviously if there's any additional treatment or other services that either party requires, that wouldn't come out of necessarily their monthly allowance, for lack of a better term.
Very well.
Paragraph 11, line 22 of page 4, include treatment services.
And there's no objection. I consider those to be medical. So it says, if you look at page 4, line 1920, it says that my client's going to pay all the copays for medical services. I just consider those to be medical. So if the court wants to add treatment, no objection.
I'll add this includes any treatment costs. Right. And then paragraph 14.
And last one, Judge, this is the case that we did spend a lot of time and argument on this. We didn't get any ruling specifically related to this password book. These parties have various accounts. My client, certainly you're aware of some of the cognitive issues that he has right now based on things going on in his life that, again, have been rehashed time and again. He relies on this password book. Apparently, during the course of the relationship, the parties had a book at the regular family home in which they operated to know passwords for everything from Netflix to these accounts. My client is asking for access to that password book. My understanding is the wife has stated to him, well, you have what you essentially need. He would like the whole contents of that book. Doesn't need the book itself, just needs copies of whatever's inside that. So again, that he has access to the accounts as well. I think that's going to be important now as we also start the discovery process, being in both parties, again, having mutual access to the same amount of unhampered access to these various types of instruments that are going to allow us to put balance sheets together and the like. So we are asking that he be allowed access to that or possession of that or whatever we can do, but just so that both parties are again, on the same page when it comes to that.
So very clearly, not pled, not argued, not ordered. This is not in their pleadings whatsoever. This is a new issue for today. It's not appropriate. We should not be ordering it. If we're going to play this game, Mr. Lawfer's already moving money in accounts, taking money out of accounts. This is why he does not need further access to additional accounts. He has his passbook. He wants my client's passbook, which will only facilitate him moving money around and taking money out, which makes Mr. Zandy's job and mine significantly harder when we have a party doing this. So not pled, not argued, not ordered. I'd ask the court just leave this language out.
And the issue is, why come back to court when we can do it now if that is in fact the argument? I mean, this is relatively simple. These parties were married for a very long time. To assume that this is her book or his book and not their book, again, it seems somewhat disingenuous. They should both have access to that. We've already got orders that say neither one of them frivolously spends money. That should certainly prevent any of what the counsel's fears are in this. And it doesn't make our lives any simpler if we've got to hunt this stuff down and try to access accounts without passwords. It is going to be exponentially simpler and save significant amounts of money if we can just have that now and then streamline the discovery process so we're not banging on each other's doors asking for information that they could have, again, with a simple exchange of a password book.
I appreciate that. This is the first I've heard of it. I would appreciate if that information could be exchanged. The parties aren't to transfer monies, change accounts, move things around. If Mrs. is willing to share that and give him access to those passwords, great, but I'm not going to include it in the order.
All right, very good. I think those are all the issues.
And may I indicate approved via Zoom, Mr. Zandy? Another presentation
absolutely.
of an
Thank
order.
You.
All right.
Actually, Your Honor, the presentation portion of this should be struck. The court signed off and the orders were filed November 28th. But we
Oh,
just
wait.
have the remaining matter of child support pending.
All right, that's not what it's, and that's not what Odyssey says. I do see that the temporary family law order was signed off on by Judge Scudder on the 28th of November, along with what appears to be temporary parenting plan. Ms. Powers did file memorandum of authorities regarding child support.
Commissioner Carmi set the issue of child support over to today from the November 21st hearing.
Correct.
Okay. All right, well, who wants to start?
I'll go ahead since the child is receiving TANF benefits, the children are receiving TANF benefits. We filed our proposed worksheets with the court on November 13th. The father's income is his actual income calculated from his September 29th, 2023 wage stub. And his deductions were taken from the same wage stub. The mother has no employment security data and indicated she's not working and she's a current TANF recipient. So we imputed her at minimum wage 32 hours per week. The issue is that we've got a joint parenting plan, but because the kids receive TANF, the court is unable to enter a residential credit. So all of this would result in a transfer payment from the father to the mother of $1,787 a month. TANF began at the end of August and as of today is still active.
Ms. Petrie?
Thank you, Your Honor. Your Honor, we concede that the state is correct regarding the deviations in this situation where mother is receiving TANF benefits. However, in my review of RCW 26-1975, the court has discretion as the options stated within the code is not an exhaustive list. Section 1 states reason for deviation include but are not limited to the following and goes into the criteria. And then section 4 also references the discretion of the court in considering the extent to which the factors would affect the support obligation. My only argument here, Your Honor, is that of equity. My client is named the primary parent. And as such, he is being obligated to pay support to the non-custodial parent under a 50-50 residential schedule. To not grant a deviation would result in an inequitable order of the support. Given that my client is the primary parent, I must question mom's actual qualification for TANF benefits at this point. I'm also slightly concerned because the Department of Child Support has already put in a wage assignment order without this order being entered. We did alert them to the fact that there was a child support action pending. Again, the outcome proposed by the state, though, will result in an order that is more in favor of one party to the other's detriment. My client is moving back into the marital home. He is going to be responsible for maintaining that home. Mother is cohabiting with a significant other. He is not working. So, you know, the idea that my client should need to support him as well is not exactly an equitable outcome either. It's just unfair, Your Honor, that the primary parent, just because she's getting TANF benefits, would have to pay so much in support. So we are requesting a deviation. However the court wants to label it, we are asking the court to exercise its discretion in awarding a deviation so as to not overburden my client and unjustly enrich mother.
All right, thank you. Ms. Lowe, anything that you would like to add at this point?
Yes, Your Honor. I can't afford counsel at this time. I was a stay-at-home mom for the last 10 years, and that was agreed upon between me and the petitioner. I don't have a track record right now of employment. I have been looking for work every single day since I applied for TANF. I am looking for residence also. I have a month. I've been given a month after being a stay-at-home mom for 10 years to find work and a home. My partner is not living with me currently. He is my boyfriend. He is my partner, but I don't have a home right now, Your Honor. I'm in the marital home until January 1st. So I'm scrambling to try and figure out what I can do and trying everything that I can to find housing and get back on my feet. But I certainly do qualify for TANF. That's why they approved it. And I'm also exempt right now. If I didn't want to look for work, I wouldn't have to right now, technically, because I'm exempt because we have a 1-year-old who I also have to find daycare for. But I am looking for work I've even applied for DoorDash. I'd also like to note that the petitioner never had problems in the past with paying for the mortgage and paying for our lifestyle. He makes a significant amount of money, always has, which is why we agreed that I would stay home. Also, I want the courts to know that for the last 4 months, the petitioner has been depositing $250 to $350 in my account every Thursday, and he was calling it alimony and support. And that's on top of what the state's asking for. I don't think the state is out of line in what they're asking for in child support, given his income. And they've submitted all of that. And certainly when I find work, my TANF will be adjusted and go down. But at this time right now, he is the breadwinner. He always has been. And I have to go from being at home, being a stay-at-home mom with 3 kids, to making everything work. So I don't know. I feel that it's fair, Your Honor, but I will leave it up to you to decide what you think is fit. Thank you.
Brief rebuttal, Your Honor.
Yes, go ahead, Ms. Petrie.
Your Honor, I know Ms. Lowe seems to think that she should be allowed to stay home forever. However, she has to remember that she's the one that made the decision to end this marriage and move on. And she's the one that put herself in this position due to her choices. And if the court would refer to the recording of the last hearing, and also in the declarations. There are not 3 children before the court today. There are only 2. My client is only responsible for 2 children. With regard to this case and the child support issue, I am requesting, again, a deviation. $1,700 is a great deal to have to pay, given the situation and my client's role as custodial parent. Thank you.
All right, thank you. So I did review the minutes from the 21st hearing. I was able to, Ms. Powers pointed out, when they filed their information, I went through the proposed worksheets from the state, reviewing the income and the information provided about the deviation based on the TANF. It is a relatively shared parenting plan based on my quick review of what was entered. And I don't see anything indicating that at this point, no spousal support was ordered. Is that correct?
Correct.
All right.
Correct, Your Honor.
This is simply for support for the children that are essentially a little over half time with father and almost half time with mother. So based on
half and half equally, Your Honor.
Don't interrupt me, please. So everything I've reviewed, I am gonna make a slight deviation. I'm gonna order $1,500 a month in support, child support, based on the numbers. And I guess Ms. Powers, would the state want that starting December 1 or November 1?
I think we would request November 1 because the children have been on TANF since the end of August. So,
Your Honor, there is an issue about arrears. The current Department of Child Support action, the administrative action, is going after him for back payments back to August. That shouldn't be happening. And at a minimum, he should be receiving a credit for the payments that he voluntarily paid, admitted to today herein on the record by Ms. Lowe. He should be credited back those payments for the ones he's already been made in any calculation that DCS might make.
Ms. Powers, does state have any position on that?
well, the difficulty is that in terms of a court order, the petition, I believe the petition in this action was filed in October, so the court's earliest child support date would be November 1st. Under the WACs, the DCS has the ability administratively to go back. Before that, certainly any court order that's entered as of the day that it starts will supersede any administrative order. I guess I'm not being very helpful here.
I'm just concerned that the child support garnishment is already going into effect with my client's employer at this time when this order wasn't even made. And they're going after arrearages that should not be gone after.
If
So some
wages are,
attention needs to be paid to the accounting on this case.
if wages are already being taken from an employer, it means an administrative order has been entered. If you give me a minute, I can verify that really fast.
I'm sorry to take up the court's time with this, but I just need to make sure my client isn't getting double dinged.
No, that makes sense.
It looks like there was an administrative order that was entered on November 16th, effective August 30th. The father would have had the ability to participate administratively. The administrative order will be superseded by this, although if our start date is November 1st, then the admin would still remain in effect from August 30th through October 31st.
And what did they set the amount at? What is he being garnished a month?
They set the transfer payment at $1,949 a month. And it looks like there's also a medical premium that they set of $487.
A month?
Yes,
So that's about $5,000 for 2 months that he's supposedly in arrears that they entered.
no, that they set current support at $1,949 a month plus $487 a month in medical.
Yeah, which is about $2,500, and that's for 2 different months.
Correct.
September and
Yes.
October.
Yes,
So almost right around $5,000 that they consider him in arrears, even though there was nothing entered by
it's
the court.
showing $5,972.74. If the court enters an order that covers the dates of August 30th on, it will supersede the whole administrative order.
Well, I don't know if I have the authority to enter an order that predates the filing of the cause.
I don't know that you do either.
I do
There's-
believe the court can set arrears at this point effective. Set the arrears as 0 effective November 1st.
Would that supersede, Ms. Powers? If the court set a specific amount of arrears as of November 1st or the filing date of this cause?
If the court entered a judgment that said it was for arrears that covered from August 30th on, it would supersede the administrative order. I would object to 0 since the kids did receive TANF at that time period, but that would be a way to supersede the order.
Except that my client was giving her around over $1,000 a month voluntarily. And she was receiving TANF.
Your Honor, the money that the petitioner was giving me, he said was for alimony, not for child support. And he also said he wasn't going to pay back TANF. We both got the same paperwork, me and the petitioner, and he came to me and said that he thought it was unfair.
Objection, Your Honor.
And I didn't pay it.
It's irrelevant.
And I guess I'm concerned because I was not aware until this hearing today that the father had been directly paying the mother. And it is true that when a parent's receiving TANF, any money they're receiving for support, either spousal support or child support, is supposed to be reported to the community service office because it's assigned to the state of Washington
That is
because
correct.
of the TANF benefits.
They're not legal payments. He's been gifting them to me as a gift because of my circumstances.
That's not how that works, Ms. Lowe. So that's a
I have talked
concern.
to TANF about
That's
it.
not how that works. Are Ms. Powers and Ms. Petrie and Ms. Lowe, are you, the 3 of you, available next Tuesday?
I am.
Yes.
Ms. Lowe, can you reach out to Ms. Powers and Ms. Petrie if we can find out how much, because clearly Ms. Lowe is indicating that he, however she wants to phrase it, gifts her approximately $250, $350 a month, or excuse me,
No, a week.
for the last however long. That's something that clearly needs to be taken into consideration, and that's something that we can potentially set the amount of arrearages at that amount and say that it's already been paid, essentially. And I think that would be a resolution to this, but I don't want to spend more docket time trying to figure out those numbers. So,
Understood. I am available next Tuesday.
all right. So, Madam Clerk, if we could just pass this matter over 1 week just to determine the amount of arrearages, and then I'm happy to enter a court order reflecting that amount. So hopefully that will trump the administrative order that was entered that has the $5,900 amount on it.
Would the court like me to have an order drafted for next week?
Sure, that would be great.
That would be
Okay.
helpful. Thank you, Ms. Powers.
Thank
All
you.
right. I'd appreciate the three of you having some communications so we can hopefully get that sorted out next Tuesday. And that is the 12th at 1
Yes, Your Honor.
p.m.
All right. thank you
Dennis
so
is
much,
present
Erin.
on behalf
Thank
of
you.
Ms. Duke. I apologize. I don't have video today. My internet keeps going in and out. I think it's the weather or something, but I am
All
here.
right. All right. Thank you.
And Tina
And-
Day, I'm here as well, Your Honor.
Thank you very much, Ms. Day. And do we have Mr. Stearns?
Yes, I'm here, Your Honor.
All right. So we're here on temporary orders. There was a motion for temporary orders after we received the guardian ad litem report from Miss Day, and we received that, oh boy, not that long ago, beginning of November. And we set over a couple weeks after there were some concerns with the GAL report. I've reviewed everybody's responses, and I would just note for the record that through the last thing I received was dated December 1st, and that was filed by Miss Dennis. So I've reviewed all of that. Technically, we're still on Miss Dennis's motion for temporary orders based on the GAL. So if there's any additional comments that you'd like to make, you're free to do so now.
I don't have very many additional comments. If you've read all the materials and the GAL report, I think the GAL did a thorough job of outlining her concerns. My client is asking that we adopt the GAL's recommendations, which she has put into her proposed parenting plan. And she's also asking that the court order father to undergo the psych eval that was recommended by the GAL with a PhD level provider such as Dr. Miharg or Poppleton or some similar provider at his expense. And she's also asking that the court adopt her child support worksheets, which use her actual net income and the last income that was disclosed by father from the previous proceedings that took place last spring. And those are her requests. If you have any questions, yeah.
Okay, thank you. Mr. Stearns?
Hello, Your Honor. I'm
Good
just
afternoon.
requesting a continuance as I have submitted material that would update the financial status I'm in and other information. Unfortunately, I was submitting it late because I'm not really sure what to do. I'm just doing my best.
Okay, so I guess,
Your Honor, we would object to.
okay, quick question, Mr. Stearns about, so, and maybe I'm not thinking about this the right way, but I guess what would your statement of financial status have to do with temporary orders? Are you looking to hire an attorney, or what would it, I guess if you could explain that to me, I'd appreciate it.
I have currently gone through different employment. I have a new job, and so I had to update my finances and what I make.
Your Honor, we would object to any continuance at the last. Oh, if Mr. Stearns could mute himself, I think
I just
we had that
muted him.
problem last time. Okay, thank you. At the last hearing, I mean, that was why I specifically asked you to order due dates for materials so that we would avoid another continuance, because I think there's some pretty serious issues here. We need to get the issues, especially with the parenting plan, taken care of. So I would ask that you just go ahead and proceed with the motion today.
Okay, and Mr. Stearns, you indicated, when did you file all this additional information? Because I don't have anything in the file. The last thing that I have was a declaration affidavit from November 29th.
I had to file it this morning, Your Honor.
Your Honor, I don't have those documents either.
Okay. All right. So there's a couple different, well, there's a motion for temporary family law order that was based in the court's purview on the guardian ad litem report that was filed back in November 2nd. There was also a motion, or I guess it wasn't really a motion, it was a declaration in response filed by the respondent in this case, wanting the court to appoint a, look for the parenting evaluator to review the GAL report because of the respondent's concerns with a large amount of information being missing, incorrect, or altered. I've reviewed everything that's been submitted at this point that I can review. If there's stuff that was submitted today, the court has not received it. And frankly, any financial position of either party isn't isn't going to sway the court as far as who is primary parent or primary custodian of the child, or make a huge impact on any decision making as far as visitation, anything of that nature. So if there's a financial issue that Mr. Stearns wants to present to the court, we can absolutely do that. I just don't have any of that in front of me today, and frankly, it wouldn't likely impact the court's decision on any temporary orders. I did see and review the proposed parenting plan, and essentially my ruling is going to be working off of that proposed parenting plan. So what I'd like to do is I almost always reserve 191s, and I am going to reserve at this point. I will state that there were some concerning comments and information in the GAL report, but at this point I'm going to reserve all 191s. I'm not appointing a parenting evaluator. Ms. Day is an independent contractor that works as a guardian ad litem with our courts, along with many other county courthouses. She has no reason to falsify information, take one side over another. She just passes on information to the court. So I respect that, and I take her information as such. So 191 reserved. I'm not going to appoint a parenting evaluator. I am going to name the petitioner the primary custodian. I am also going to, and this is a little bit unusual, but I think there's things that we need to hopefully strive for in this temporary plan. So as far as decision-making, extracurricular and school, I'm going to make joint, and medical non-emergent, I'm going to appoint the mother as the decision maker for that. This is really based on the ability of the folks to cooperate on certain matters. But I think that extracurricular and school seem to be kind of a common area where everyone wants the same things. I stated that the petitioner will be the primary custodian. The difference in the parenting schedule that I am going to make is I am going to add the fifth weekend. So it's first, second, fourth, and fifth weekend of every month will go to father. All the other suggestions I am going to adopt. And that also includes the Wednesday after school. If that conflicts with any extracurricular activities that the child has, if the parties are able to agree on some other time, the courts, I'm fine with that. But everybody should respect that if the children are involved in extracurricular activities, that they have responsibilities to those events as well. Neither parent shall discuss the case with the children. I want to make that very, very clear because some of the comments, not only in the declarations that were provided to the court, but the GAL report, it's pretty obvious that these children are being included in some of the information that has to do with this case, and that is absolutely and wholly inappropriate. So that should not be happening. There shouldn't be any pressure, guilt, anything put on these children based on this court's decision, so that if the court does find that these children are aware, scolded, spoken to, anything regarding the court's decision, that's not going to be looked upon kindly. That goes to both parents. I just also want to emphasize there was a lot of language in some of the information that was provided. My boys, these are my boys. These are not your children. These are your children, not my boys. You need to work together. You were at one point a couple and got along enough to have these two and what sound to be great young men. You need to figure out how to raise them together and adjust to the two new families that they're going to have to be living amongst. So it's not just you that are going through all these frustrations and changes. These two young people are having to adjust to these new situations as well. They should be allowed to call any of the adults in their lives, whatever they want to call them. I know Mr. Stearns vehemently objects to any comments that children aren't allowed to call their mother and only can call his significant other mother. Frankly, that information came from the children. So children should be able to address the adults the way that they want to address the adults and not be not have any shame or guilt in doing so. I went through the requests for the mental health evaluation, and I'm going to reserve on that. I know that that's something that can take a great deal of time. My hope is that because, and I frankly want to apologize, that this case started in April of this year. Excuse me, February of this year, and it was first heard in March of this year. No temporary orders were entered. I appreciate that the parties have worked together somewhat to get kind of a schedule going for these kids, but the court didn't enter any temporary orders really from the outset. And I get that can be difficult and frustrating. So I'd like to see how the parties operate working together under this temporary order. And if there's any concerning activities or issues that arise, I'm more than willing to reconsider the request for a mental health evaluation. Any questions at this point?
I have one, Your Honor. You said that there was nothing submitted early on. I submitted temporary parenting plan and everything March 30th.
No, I said nothing was entered by the court early on. So no temporary orders were entered until now.
Okay.
So that's no fault of yours. That
Okay.
you did what you were supposed to do there. No, that was, in my opinion, the court should have entered temporary orders months ago. And so I'm apologizing that didn't happen when you were in front of on a different docket. So, but my hope is that now that we actually have temporary orders from the court and you can get into a routine, hopefully things, you'll be able to start working together for these two young children.
Okay. I just have to say that the only issue with working together was Samantha most of the time. It was.
Well, I've read some of your text messages, Mr. Stearns, and I would disagree with that. So, and I'm not blaming you entirely. I think both of you need to work together. So that's my hope. So let's have a fresh start. Hopefully we can have a fresh start with this new temporary parenting plan and see where we can go from here. Ms. Dennis, do you want to set a presentation time, or do you think you can work with Mr. Stearns to get something entered?
I think we should set a presentation time just as a backup in case we can't get something agreed. I probably can't get it. I could probably get it done by the 19th if you have a docket that day.
You do. I have the 19th at 1 p.m.
Okay.
Does that work for Mr. Stearns?
December 19th?
Yes, that's 2 weeks from today.
That should be fine.
And if you, Mr. Stearns, if you agree with the order that Ms. Dennis drafts, that it says what I said today, and you want to sign off on that, then we can strike that hearing and you don't have to appear on the 19th.
Okay. I also have a question about the information that I submitted today. Is that not going to be considered at all?
Not for the temporary plan. If you want the court to make a ruling on that, you need to file a motion for the court to do so and note it on the docket and give notice to the opposing counsel.
Okay.
Petitioner's
I was just wondering.
Did include a request.
I'm sorry, Ms. Dennis?
Your Honor, I'm sorry. The motion did include a request to determine temporary child support. So that's where the financial part comes in. And
that's part of the paperwork I submitted today was updated finances.
And that's something I guess we need to clarify for Mr. Stearns too, is that he needs to serve me with anything that's filed and he needs to file it timely because that has not been happening. So I just want to be very clear that that's expected.
The only
email is fine, but I need.
Okay. The only information I have, Mr. Stearns, right now on financials is what's already been submitted prior to today. And the proposed worksheet from Ms. Dennis. So let's on the 19th, let's review child support as well, because I don't obviously if his employment has changed, that's something that the court would need to address. So I'll reserve child support for the 19th at 1 p.m. So we will have a hearing on the 19th at 1 p.m. But Mr. Stearns, you do need to make sure that whatever you filed is at the very least emailed to Ms. Dennis. She's willing to accept that via email. So she has an opportunity to see what you filed with the court.
As
Okay.
well as regarding the item, Your Honor, I have not been served with any of the documents. A lot of those came late, or I found them online.
All right, thank you, Ms. Day. So you also need to make sure Ms. Day receives a copy of that as well, Mr. Stearns, okay?
Okay.
And I'm assuming Ms. Day, you'll accept email, I would assume. Ms. Day,
Yes, sorry, I couldn't
Okay.
get it to. Yes,
Perfect.
email is.
email's fine for both of them, Mr. Stearns, okay?
Okay.
All
Like
right.
I said, I'm trying my best, and I didn't know I had to email Tina Day, but I will include her. My apologies.
No worries, I appreciate it. All right, we'll see you back on the 19th.
Thank you.
Your Honor, I just have one short clarifying, not really a question, but just I kind of just want you to clarify something. So I know that in the past, one of the big issues with conflict between them has been extracurricular activities and whether or not the children should even be allowed to do them. So I just was thinking, I think it's appropriate for the kids to be in extracurricular activities. If you could maybe encourage that for the parties. Because I don't want to be in a situation where if they have joint decision making, one party is just saying no, and then we end up back in court here within a matter of, I'm sure, very soon, given the history here.
The information that I reviewed, it sounds like you have two very active young boys. I think extracurricular activities that they are interested in are absolutely in their benefit. So I would hope that the parties would be able to agree on that.
Okay.
Hello?
All right. Thank you.
Thank you. All right, we're here on a motion filed by Mr. Anagnostou for reunification counseling. When I reviewed this matter last week, there was no response. When I looked at it again earlier today, there was a response. But frankly, I have a question before we even get that far. I understand the reunification request. I reviewed the initial parenting plan, or it's not the initial, the final parenting plan that was entered, I think it was 2021. Or was it 2017? Am I confusing? Let me see here.
I believe it was 2017.
Yeah, there it is. It's July of 2017. My apologies. And there is a laundry list of items that Ms. Nicholson is required to participate in, take care of, however you want to phrase it, before we get to this point. But additionally, one of the other things that the court is required to, based on the final parenting plan, to take into consideration, and frankly, I didn't see any comments on this at all, was the child's, Stephen's counselor's position on not only whether it was appropriate at the time for this to take place, but also for the court to consider the child's position with any reunification. And I didn't see anything that had to do with that. Does anybody have any information there?
Stephen has expressed, well, it's hearsay. There's nothing I can say on this.
I guess, Mr. Anagnostou, you're muted. To me, it looks like a two-part issue. So it's not only has she done all the things that she needs to do, but is it appropriate for the child? And the secondary thing is this child is 2 months away from being 18 years old. So how far along in any reunification are we going to get before it's really out of the court's purview? So
the child has his own email, he has his own phone, he has his own car. He knows that he is welcome to contact Ms. Nicholson or anybody in her family. He's maintained contact with some people, mostly his aunt and some of his cousins. If this is something that he wants to do, he will do it. And on a practical matter, I can't imagine how I or the court would force him to talk to somebody that he doesn't want to talk to.
Mr. Anagnostou?
Yes, in response, the order indicates that Stephen shall remain in counseling. We don't think that that's been complied with by Mr. Nicholson, and that they shall provide proof of Stephen's counselor and contact information. We asked for that. Ultimately, he gave us the name Sierra DeMuth, and we contacted her and got the implication very strongly that she's retired, her office is closed, and it seems like it's been in that condition for a very long time. So we don't know when Stephen last went to counseling. He's supposed to be remain in counseling. But in any event, my client, the reunification counseling, pursuant to the order, it indicates that before visitation may be reviewed, Stephen's counselor shall establish that Stephen is strong enough. And that's where we're at right now. We just want to do that.
Well,
So we have contacted Melissa Gard, Miss Gard, who's a counselor up there, and she's willing to sit down with Stephen and have that conversation. We don't believe that Mr. Nicholson is telling Stephen that my client wants to contact him and wants to have a relationship with him. We think he's shielding Stephen from all that, but we simply don't know. It's a very simple thing for if Stephen's driving, that's fine. He can go see Miss Gard on his own and talk to her and tell Miss Gard, yeah, I know my mom's trying to contact me. I don't want to have a relationship, and convince her that that's in his best interest, that he doesn't have any relationship with his mother. Now, my client has appointments with has set up appointments with Melissa Gard in advance because we know we're on kind of a short time period here. So she can see Stephen on December 14th and sit down and talk with him. He goes to her office and we will then know that he's at least got the message that my client loves him, misses him, and wants to have a relationship with him. If he convinces Miss Gard that he doesn't even want to do a Zoom here, I mean, Mr. Nicholson's response brings up guns and all sorts of stuff, but how's my client going to shoot Stephen through a Zoom meeting? I mean, that's what he's implying. She doesn't have guns, by the way. She's complied with all those orders, but in any event, that's what his response is about. This is going to be by Zoom, and we'd like to get it going sooner than later, and especially over Christmas, so that my client can get this message to her son. It's simple enough. Stephen takes himself to Melissa Gard's office on December 14th, talks to her, and then she has another appointment set on December 21st. If he agrees to a Zoom conference, my client can have a conference on December 21st with him over Zoom and Miss Gard is going to be there, so there won't be any inappropriate comments. If there is, I mean, she'll shut it down. She's a professional in these regards. So that's what we'd like. We'd like to come out of this with an order that Stephen is to go to Miss Gard's office on December 14th, and we go from there with regards to where we're at on reunification counseling, on my client being able to contact her son directly.
Your Honor.
Yeah, hold on one second.
Right.
No, it's okay. I just so Melissa Gard is with Gard Mental Health in Friday Harbor. So I just want to confirm she's an individual that your client has not been seeing independently. This is just sort of a
We have
neutral.
no idea who this person is.
I'm asking Mr. Ignacio.
Oh, I'm sorry.
That's okay. This isn't someone your client has been seeing. This is just a neutral sort of third party that specializes in this type of reunification.
Yes, my client didn't even know who she was until she was referred by Sierra DeMuth, Stephen's counselor, or at least past counselor. Okay. So she had no idea who she was, and she's been working with her to get this set up. Actually, Ms. Gard has been on vacation, but she's been communicating by email both to my client and to Mr. Nicholson. So he's aware of her communication. Okay.
Thank you for answering that question. Mr. Nicholson, go ahead now.
Your Honor, I think we're kind of missing the point of this exercise. There was a reason that the judge put protective orders in. This Miss Nicholson horrifically traumatized and terrified a child over a period of many years, and in a manner that was so egregious that not only did she lose contact, and she was given restraining orders that did not allow her to come to this island, did not allow her to have guns, was directed in no uncertain terms to approach the mental health differently, because it was very clear at the court during the trial that the statements of her treatment providers could in no way be relied on whatsoever. And she has had 7, 8, I've lost track of how many years, almost a decade to get appropriate treatment, to have these hearings. And here we are literally weeks away from a young man being outside of the jurisdiction of this completely. And I don't believe on the record that the order has been complied with. The order was to protect Stephen and to a lesser extent me, but the order was to protect Stephen from Miss Nicholson's emotional state and the things that she did. She has not complied with that. Stephen doesn't have to convince anybody that he owes this to her. I don't have to convince anybody that it's perfectly fine for her to re-traumatize him or even put him in that condition. He is a few weeks away from being an 18-year-old adult outside of the jurisdiction of this plan. There is no point in forcing him to do anything in this realm. This makes no sense, and why we're waiting until he's 3-4 weeks of being 18-year-olds, and then we're going to force him into these counselings and this makes no sense. This just literally makes no sense. And I don't even think we get to the point where we talk about that, because I don't think we've satisfied the conditions to even be discussing this on a number of levels, on participation, providing input, on people giving us records. You don't know, based on the records that Miss Nicholson has picked out, whether or not she's ever dealt with the abuse of Stephen, why she's not going to do it again. I don't know that because they haven't given me any of those records other than what she's handpicked out, which talk nothing about Stephen. They talk about her and her gun and she's okay, and they look exactly the same as the ones that she supplied for years while she was abusing Stephen. This is not something, it's too late.
Thank you. Mr. Anagnosio,
And just a brief response. Mr. Nicholson is bringing up the information. We provided all the releases pursuant to the order. It says that we're to provide releases. I just want to point out that in the documents we supplied, we have some letters from Dr. Jan Johnson, and the first couple of ones are older, 2019, where Dr. Johnson was contacting Mr. Nicholson. He even sent Mr. Nicholson an email, which we provided. And in the next letter, he says that he's been trying to contact Mr. Nicholson by phone, and he puts the phone number in his letter, and he's left voicemail. And so, my client's treating physician has been open to Mr. Nicholson getting information. We sent the releases, but all that's, beside the point. What we want to do is start the reunification process, which is a reunification counselor sits down with Stephen and see how he is going forward. What is wrong with that? It's not opening, trying to re-traumatize him or anything. It's trying to heal those wounds. And the counselor will make that determination. She's a professional and she's worked in this area for many years, and we provided some bio on her, Miss Guard, and we don't see it's Mr. Nicholson doesn't want to comply with this order with regards to him remaining in counseling and doing these things, it specifically indicates that that's the first step. Before visitation may be reviewed, Stephen's counselor shall establish that Stephen is strong enough to endure contact with his mother. That's what Ms. Guard would do. And we should take that step now. So before my client doesn't have the opportunity to tell her son she wants to have a relationship with him, she loves him, and she misses him.
Okay, here's how I see it. The order does require that Stephen remain in counseling as determined by his counselor. So I would take issue with Mr. Nicholson not following a court order. If the counselor felt that Stephen was doing well and didn't need continued counseling, then that is in compliance with the court order. And I don't think I have any way to say if that was last year, 5 years ago, however long it took. My assumption is that I think the assumption should be, frankly, that was complied with. I did review the sealed personal healthcare records. It does appear that there are medical release forms that authorize Todd Nicholson to review and gather documents from, I see at least 4 different providers. It looks like maybe 4 or 5 different providers. So that does appear to comply with the court's order if those are the services that service providers that Miss Nicholson has been seeing. As to the reunification counseling, frankly, I really agree with Mr. Nicholson in a lot of what he's saying. Is this too little too late? Where I would kind of veer off is we do have jurisdiction for another two months approximately. I think February 11th. Is that February 11th is 18th?
February 11th.
That's correct, Your Honor.
So would it be better for him to have one conversation with a counselor next week in a controlled environment, or, and I'm not suggesting Miss Nicholson would do this, but he turns 18 and then she tracks him down and out of the blue, he starts getting contact in an uncontrolled environment. Arguably, it would be better for him to just have a conversation next week with a counselor. And I would agree again with Mr. Nicholson. I don't think he has to convince the counselor that he doesn't want to do it. If he doesn't want to do it, then it's over at that point. So I will, I guess, start the process that the parenting plan from 2017 allowed for. And I would ask that Stephen, assuming that the 14th works for his schedule, I don't know, is he still in school at this point?
Yes.
So assuming that Miss Guard, and she seems to be a neutral party, that there's no ties to either side, that he scheduled an appointment as with her if the 14th of December works. Sounds like Mr. Agnosto, she's kind of reserved a spot.
Yeah, and she
for
reserved
this?
it at 3:30 in anticipation of him being out of school by then.
Okay. And if that works for Stephen, I'd ask that he attend that appointment, participate in whatever manner he feels is appropriate. If he's, if this is, frankly, if he goes to the appointment and sits down and Miss Guard says, this is what this is about, and he says, I don't want to do that, then he's participated in that situation, and that can be relayed to Miss Nicholson. So, but I would enter an order that Stephen should attend an appointment with Miss Guard. If Stephen wishes to do a secondary appointment with Miss Guard and Miss Nicholson, that is entirely up to him. So I'm giving the ball's in his court as far as what the next step is. But I am going to ask that he meet with Miss Guard, and hopefully that can occur on the 14th at 3:30. If not, that to schedule an alternative time as soon as all the parties are available. So do you want a presentation for that, Mr. Anagnostou, or I know you sent something. Hold on.
I will get an order over to you and to Mr. Nicholson, and very shortly. I got a kind of a standard order, and I'll just write in the comments that you just made, and I'll get it right over to you.
Your Honor, what I would request is that if we're going to enter an order, that we stick to the singular thing that we've agreed to it here, and not imagine a whole bunch of things that may or may not happen.
I'm only ordering the first meeting with Stephen and Miss Guard. Right. If Stephen chooses to go to the next meeting, and frankly, he may want to say, I want to see Miss Guard one more time before I make a decision.
Right.
That's up to him. I'm only asking for the initial.
And I think, Your Honor, I'm very comfortable with this being left up to this young man who is in charge of his own life. This is his stuff.
This is his stuff. I would agree. So, Mr. Anagnostou, if you want to route that through Mr. Nicholson, and I'll happily sign it ex parte. If there's any concern with that, you can throw it on my presentation docket on a Friday morning, or I don't think I have any Tuesdays upcoming that are closed.
Okay. I'll get that right out.
Okay. All right. Good luck. Thank you.
Thank you.
And I did see, let me see, there was an email that your office sent Miss Baldwin with an updated sheet. Let me just.
Yes.
I get so many emails, things get buried so quickly. Let's see here. When did you send that, last week, or was it earlier this week?
It must have been last week, because my filings shows December 1. So it must have been last week. probably Friday.
Okay, so the respondent's debt calculation, I see the updated, it's dated from the Division of Child Support 11/29/23. Okay.
Correct.
Do we have Mr. Gilliam?
And not Mr. This is Mrs. That is the.
Oh, I'm sorry. We have Miss Gilliam, which is, I'm sorry, Stockwell now.
Yes, she was. Oh, and there she is.
She's here. Yes.
Yes. So we're on here today for review regarding contempt. And my concern is we really have not changed course. If you look back through the pleadings, we started the contempt back in April. It took us some time to serve Ms. Stockwell. We were before the court, I believe in June. And then we had a review, and then we set this review out even further. The issue here is that when you look at the debt calculation, we have no child support payments made in January going all the way to June. We have her basically getting served, the court kind of giving her some ultimatums. So we see a small payment in June, a small payment in July, and then once again, nothing in September, nothing in October, nothing in November. Here we are, December. So if you look at this sort of little debt calculation just for 2023, and assuming, here we are December, not seeing any payments made. So essentially over the course of a year, we have 2 months out of 12 where anything has been paid. And I always have a concern when somebody pays nothing, month after month of $0 paid. So it's not, I couldn't scrape together 20 bucks. I couldn't scrape together anything. And so that does get to where we're talking about intransigence, is somebody who just says, not going to do it, and you can't make me. And that's where the teeth of the sanction, unfortunately, need to get sharper for Ms. Stockwell. My client's been very patient. We've kicked this out, for not just like a month or 2 weeks, get a payment, but sort of like months at a time, saying, hey, kind of get it together and start making a plan and start making payments. And Ms. Stockwell just, instead of sort of taking that grace from the court and from my client, has kind of just blown it off. At this point, we've been at this again since April when we filed the contempt. We're kind of done with some of those simpler encouragements. And we're at the point where we need some teeth to get Ms. Stockwell to get real about the fact that she has to make payments. She has to pay child support. So at this point, I think what is most appropriate, we've got a couple weeks. So either I'd like to come back on the 26th or, in my preference, it's the 26th because Your Honor is here. And I know that the docket changes in January. But essentially, I'd like to see some real payment this month. And if she doesn't, that she shows up on the 26th in person, ready to spend some time in jail until she writes a plan on how she's going to pay. Because so far, none of this has gotten through to her. And it's been an extended period of time where these children who are entitled to support aren't receiving it.
Thank you. I just, for the record, I do see that, so there was an order on contempt that was entered in June for the April contempt. And then there was, it appears, a satisfaction or partial satisfaction, a judgment in July after another, after the amended tax return was ordered. And then in August, there was another $250 in attorney's fees ordered. I'm assuming that, or has that been addressed? No.
No, she has not paid those. And we've tried to give her credit anywhere where it's appropriate to do so. And you can kind of see from that debt calculation that in August, she paid a little bit over the total arrearage, I think by about almost $300 over the sort of monthly amount towards the arrearage, which was good. But then once again, no payments thereafter.
All right. Ms. Stockwell, any updates for the court here?
Yes. So we have been trying to figure out how to piece together a plan because the day after I had my baby, we got hit by a drunk driver and my car got totaled. So I haven't been able to return to work for lack of transportation, and lack of childcare for lack of transportation. And we've been scrapping together and trying to piece together money, and neither of us felt like the $20 would make a difference. So we've been trying to make sure we are able to pay a lump sum so it doesn't look like we're just, here's pocket change sort of thing. We've been trying to rework billing. We've put off paying multiple things, just trying to come up with the money. Right now we're in this space where if we have to choose between paying the child support or paying rent. And I can't in my right mind put my brand new baby and my stepdaughter homeless to pay my ex money for the kids when he's making more money than we are on a regular basis. I would absolutely love to be paying them. I would love to be able to help support them. That is my goal. And my boss is very understanding about the fact that I can't get to work. She said, as soon as I am able to get transportation, I'm able to start right back up. We've been keeping in contact every 15 to 14 days to make sure that I'm still trying to find a car. I've reached out to family members to see if they'd be able to help so that I can get back to work and get back to paying. Where there were payments to the child support, those were months when I had a steady job and had finally gotten all of the auto like taken out of my paycheck directly sort of payments, so that it was one less headache of trying to schedule payments and get everything figured out. I have applied at jobs for stay at home. There's not many that are actually hiring. Just kind of a, hey, apply. And then I never hear back from them. I just heard back from a job that I applied to in January saying that they were full and didn't need anybody. But I've been applying for jobs stay at home wise so that I can still be able to put money towards this. But if the $20 is going to make a difference, I will send the $20 we have or the $5 or whatever we end up having left over. I will gladly send it. I just didn't think that was going to make that big of a deal, or even really look good to the court's eyes for me to be sending pocket change. So my apologies for not knowing that that would be such a big deal. And that's about all I can say right now with not being able to even get to work currently to help pay for this.
Briefly.
Yes, just so I just want to confirm. So, and I'm sorry to hear about the car accident. Nobody was injured. Everybody's okay, other than the car, I guess.
No lasting injuries.
Okay, I'm glad to hear that. Yes, Ms. Baldwin, go ahead.
So unfortunately, these are sort of similar story, different day. Anytime we come to court, it's always sort of a woe is me. Gee, all these things have happened, and perhaps that would make sense to consider if we were in a situation where I set the review like 2 weeks and we were sort of dogging her the whole time. This is a case where we are setting reviews out months at a time, giving her an opportunity to sort of get it together, and she never does. She makes these choices of, I basically want to be a stay-at-home parent to this new child that I chose to have and to my boyfriend's child. Instead of, the boyfriend has an obligation to take care of that child. That is not her obligation. So these are choices that are being made, and perhaps collectively between her and her boyfriend, but there's ones where they're consistently over a year, 10 months out of 12, deciding that the 2 children that she had with my client deserve $0. So again, we're making choices, and she's had a year at this point, or since April, I guess, since we filed the contempt, to get these things together. She just never does. And unless there are some true teeth to the court's order, she is never going to do so. So that's where, we've put it out long periods of stretches, hoping she would get things together. She just isn't. And unfortunately, we need to have a harsher penalty. And I believe that'll unfortunately result in action, because so far what we've done has not resulted in really any action on her part. It's all, gee, I wish I could, but even now there's no stated plan on how she's going to pay. It's completely vague of, here's what I'm doing, here's what I've done. It's sort of all, well, if something comes around, I guess I'll pay, but that's about it. That's not appropriate when we're talking about child support. The children in my client's home even deserve support. This is a court order, not a, gee, we'd like you to do this some period of time.
So, I understand the frustration, and I understand Ms. Stockwell's circumstances. We unfortunately, it's unfortunate the court often sees folks have kids and without the forethought about how they're going to support those kids. And in this case, it's I understand the frustration here. There was an order of child support entered in January. that changed the support, the temporary support, and in the most recent debt calculation, it appears that as Ms. Baldwin stated, there was a payment made in July of $90 and August of $780 for a total of $870. And the arrearages just for this year alone are over $5,000. So while I understand making decisions between being homeless and providing for other children, there is an order in place. So here's what I will set a review for December 26th at 1 p.m. I would ask that Ms. Stockwell be present in person on the 26th at 1 p.m. However, Ms. Stockwell has until December 15th at noon, so that's next Friday at noon, to provide a plan to Ms. Baldwin's office regarding payment of child support. As you know now, Ms. Stockwell, some payment is better than nothing. No payment is kind of like a middle finger to those other two children that you have, and that's not appropriate at all. I appreciate you saying, well, we want to give bigger chunks. Doesn't matter. Frankly, the court would see a $25 a month, $50 a month payment as much better for everyone than 0.00000. If the plan that's provided to Ms. Baldwin's office is acceptable to Ms. Baldwin and her client, that date on the 26th can be struck. And if you want to renote it for another review, by all means, we can do that. If it is not acceptable by Ms. Baldwin, and so I'm putting the ball in Ms. Baldwin and her client's court for this. If that plan is not acceptable, then I expect Ms. Stockwell to be in person for court on December 26th, 2023 at 1:00 p.m. on the second floor of the Hall of Justice. And I guess the implication, Ms. Stockwell, is the court is most definitely considering jail time in lieu of child support, as this is just, it's gotten out of hand, and it's only going to get worse and worse the longer non-payment happens, and those arrearages are just going to keep growing, and then interest will start applying, and it's not good for anybody. Okay. So Ms. Baldwin has the authority to strike that 26th. And if they don't feel the plan is sufficient, and frankly, if there's some negotiation between the parties after you review the plan, I'm fine with that. I feel like Mr. Gilliam and Ms. Baldwin have been willing to work with you, Ms. Stockwell. So, the sooner you get a plan to them, the more opportunity you have to have some discussions with them about how you're going to address this moving forward. Okay. Any questions or concerns?
Okay. Very good.
It looks like, I think there was a
Thank you. All
declaration
right.
filed after our last hearing by Mr. Anagnostiu.
Yes.
So I'll start with you, Mr. Anagnostiu. Any information at this point you want to add?
We updated answers. Mr. Wanzer was asking for some additional bank statements and pay stubs and those kind of things, and we updated them with the information that we had. So, but in the interim, I received his updated answers to interrogatories, and I provided you some of it. He is just, he's just refusing to answer interrogatories. And I pointed out some examples. Some of them are, easy enough, whether he's got a 401k or IRA or those type of things. But question number 75, we asked to see income information and tax returns and those type of things. And, his answer is he's got this stamp now that he's stamping all over them. Apparently went out, he has time to get that, but not time to get me the information. And in his second answer to our request for pay stubs and for income tax returns and those documents, he stamped the objection that it's just, he's not going to provide it. And so I'm frustrated. My client has ran up significant attorney's fees in responding to Mr. Wanzer's repeated requests and trying to get the discovery that we need to go forward with this case. So I'm asking for attorney's fees. We need to get Mr. Wanzer to cooperate. And if he doesn't, I guess strike his pleadings and my client can finish the divorce without objection from him.
All right. Thank you, Mr. Wanzer.
I'm kind of in the same boat here. It's been 151 days. and I've been waiting for answers from them. And I got partial answers, did not get any answers, not all the answers. And some of the stuff that I have is blackened out. And I emailed Mr. Anagnostou on the 14th and let him know that I had from the 24th to the from the 20th to the 24th off due to an involuntary lack of work. We had the tree farm was shut down for Weyerhaeuser and we weren't working. I had all those days. I emailed him, no response. He did not respond to me at all. And as far as I never got a letter of discrepancy regarding my prior answers. So the only thing that I had to go on was what he had mentioned to you in court, which was my military status, my social security number, my 401k that I never have had, or, I mean, I emailed him all the stuff that he was asking for. And then I get this email from Sam Anagnostou on the 29th requesting a 26I conference. Well, I'm working out of town. I work down at the coast. I work in the woods. So I said, well, can we do it on Saturday the 2nd? And I never got no response back from nobody on that one. Then, let's see, it was on December 1st, I get emails of documents, 202 pages of 90% of the stuff that I've already had. That really was not answered. I mean, it was duplicate of what I already had. That he'd already emailed me. And he sent it to me. I've lost, this is my 5th court date, 5 days that I've missed work.
Anything that indicates that they have not complied with your requests for discovery. If there are things that they have not given you as part of discovery, specific things that they have not given you, you're free to file a motion to limit the presentation of evidence on that. And that goes for Mr. Anagnostou as well. If we're in a situation where you are refusing to provide something or are being objecting, and I already told you that the last hearing that a lot of your objections are completely baseless and not legally centered, I'm talking now, then that can be limited. Then that information doesn't come to the court. And when the court tries to decide your divorce, nobody gets the benefit of that information. That's where we're at. You denying them discovery denies the court discovery. Because that's how it essentially gets to the court. So if that's how we want to do it, and you want to only have partial information to the court for the court to make a decision that could potentially be extremely detrimental to you, then by all means, I'm talking still. Then by all means, don't comply with discovery. If Mr. Anagnostou files a motion, or if you file a motion about specific information that's not been provided and are asking for limiting instructions, at this point, I'm likely to grant it, barring any contrary evidence. At this point, I cannot, between husband and wife, 2 grown individuals, sit here and monitor the discovery that's going back and forth. That's not what I need to do here.
Oh, I understand
that is not the court's job at this point. There was a 26I ordered. The motion to compel that you filed, it appears to me has been responded to, and there's been nothing that says that those responses are not sufficient. And now the evidence is showing that you're refusing to comply with their interrogatories. Okay, great. If there's a limiting instruction from either side, that's something that the court will deal with. But at this point, I'm not going to mediate this situation as far as discovery. It's gotten completely out of control. I've already told you, Mr. Wanzer, a lot of your objections are not based in the law, and that information just may not go to the court, and that could be to your detriment. Could be to your benefit, could be to your detriment, but that's kind of where we're at. And if the parties agree to another 26I conference, great. But at this point, that's already been done as far as the court's concerned. I believe Judge Scudder ordered that in October, and it was done in October. So I'm denying the motion to compel, which is the only thing that's before the court today. As far as attorney's fees, I'm going to deny the request for attorney's fees at this time. I would reconsider those if there's any additional motions filed.
Okay, can I speak now?
If you want, I don't know that there's anything more that we need to discuss.
Well, most of the questions that he's asking are on the file. I mean, all my military, all the questions like that he is asking are on the file.
Is your driver's license filed?
Yes, it is. Yes.
Where?
It's in the file. Everything, took copies of my driver's license, copies of my social security number, wrote on there that no, I was never in the military. Everything is in the file that I filed. When I first started all this, it's all in the file.
I looked through everything that's in Odyssey. I've been, I think, the judicial officer for this entire case. I didn't see any of that information filed with the court. If that's, and I understand everything isn't filed with the court at this point in time. If you have filed it, indicate when and where you filed it, or when and where you sent it to him. That'll be compliance. If he files a limiting and you're like, nope, I gave it to you and I gave it to you on, July 1st, I'm going to consider that. And then I'm going to tell Mr. Agnostu, okay, he gave it to you. But I'm not going to just, nope, I did it. You did it. You didn't do it. We're done with that. So we need to get through this case. And if discovery is taking this long, I don't know. I don't have high hopes for the resolution of this case coming anytime soon, which frankly seems to be the opposite of what all the parties want. So let's try to work together to get this taken care of. If there's specific requests and you've already taken care of them, just say, Mr. Agnostu, I gave it to you on this date. Here's what look for it on this date. Okay. All right. Good luck.
Thanks, John.
I have this for child support. And
correct,
here is, I'm gonna turn a light on here, hopefully. I have a little bit of frustration here that I'm just going to let everybody know. So I haven't reviewed, and this is not, it doesn't appear, I don't know what happened. So there was hold on, declaration affidavit that was filed by Ms. Olson on the 27th of February, indicating that she attached an updated child support order and Washington child support worksheet via the Division of Child Support's website. That's index number 86, Mr. Baldwin, if you're in Odyssey. Nothing was attached to that except for Exhibit A, which was a pay stub. I get my orders for today's docket. And in the orders for today's docket are the child support order and child support worksheets that I'm assuming Ms. Olson alluded to. So I have not reviewed those. That's what I wanted you to know before we get started. So I don't think that that's Ms. Olson's fault. I just wanted both parties to know that I didn't have an opportunity to review those prior to a quick review this afternoon. So, okay, Mr. Baldwin, where are we at?
Well, so this case had various other parts. Your Honor may recall, originally heard a couple of weeks ago in front of Commissioner Carmi. Everything was resolved beside the child support. Ms. Olson filed a motion regarding child support. The issue is before the court involving an original temporary order from December of 2019 up to what is ostensibly addressing a modification of support based on some additional information. It's Ms. Olson's motion, so I'll defer to the court in what order we proceed.
And that's the child support's the last remaining issue at this point. Is that correct?
It is, Your Honor. There's an issue of retroactivity, Your Honor can see from our declarations. For the court's information, maybe to help with some of the scope, the December 16, 2019 child support order was based in a period of time where there were 3 children of the marriage that were subject to the temporary order. A son who was residing with the mother, and then 2 daughters who were residing with my client. The child support order at that time resulted in a transfer payment by my client, even though he had 2 of the children because his income was greater, of a couple $100s a month. In July of 22, that son aged out, effectively turning 18, resulting in no more offsetting obligation for support. Because of the manner in which the order was written, it did not create anything actionable for support enforcement to enforce any support obligation against the mother, even though there was a child support worksheet and order reflecting support for the girls in my client's care. She, before we were able to effectively made the motion to address support, as indicated in her motion, because she wanted it to be clear that she was willing to pay support. And that brings us to where we are today. In addition to the worksheet that was attached to the 27th filing, there are a couple other worksheets that had been filed by Ms. Olson that I'm prepared to address in our argument. But I think the issue is what would be the court's ruling on the basis for the retroactive support to the point at which the son aged out and only the daughters were remaining. And then as far as the new income values, what is support moving forward on the motion that was filed in September.
And when did the son age out?
I believe it was July 20th.
June 14th.
June 14th.
June 14th is his birthday.
Of this year?
Of 22, Your Honor.
So a year and a half ago, approximately.
Yes, Your Honor. My staff, when they did the back pay, I think went to the following month. July 20th is what was in our proposed order from our original filings and child support worksheet. So we set it from the next month.
Okay. All right. Thank you. Ms. Olson, good afternoon.
Hello.
Any comments that you would like to provide?
Well, my comments are in my declaration, basically stating that I feel like I shouldn't have to pay him that back support because I've been supporting our daughters this whole time. It hasn't been going to Mr. Olson's bank account, but I've provided, an example of the in-kind support that everything that I've bought them in the last 6 months. So I feel like I have been supporting them. He doesn't owe any money. I just feel like I shouldn't, just because Justin turned 18, he is not asking for child support until this last August. So, I mean, I don't have $20,000. I have like, $50 till I get paid on 15th. So, it's just going to put me in debt. I don't think I should have to pay him $20,000 when I've been financially supporting my daughters this whole time. I take out a loan every, summer to get them school clothes. I buy them, their expensive shoes. And I do whatever I can for them. He makes 3 times as much money as I do. And, we agreed that they would go stay there because, he has more room and he's more financially stable. So, that was an agreement between the both of us. And so all of a sudden, he wants child support, and that's fine, but I don't have the means to pay him 19,000 whatever dollars just because they want to go back when our son turned 18. That's not fair to me when I've been supporting them financially in whatever I can, wherever I can.
And are we still pending trial on a final parenting plan?
Yes, Your Honor. The court 2 weeks ago basically made no change to the temporary. Mother hasn't put the matter on. What I'll say is was addressed at least somewhat when we were in court previously. And this all came about with the mother's filing because my client had a letter sent to her. There's a contempt finding by the court because she unilaterally took one of the girls for tax filing. Despite the current temporary order prohibiting that, giving the tax filings to my client. We would love to have an agreed resolution and finalized. We don't have that at this particular point, so there is still just a temporary. As to the arrears or the back pay, I've done the math. The amount by my count is anywhere between roughly $6,000 and $16,000 based on whether the court sets it at the amount at the time of the support order with the incomes and the obligation from December of 2019, or whether the court sets based on the current amount, how far back. I can give the court some more detail if Your Honor would like at this point.
On the arrearage?
Yes, Your Honor.
Sure, go ahead.
So looking at the child support worksheet that was part of the order in 2019. The worksheet showed a base child support amount for each child of $727. Even if it's kind of, say, nebulous, but if you were to take that amount as set and only have the 2 remaining daughters at mom's 24%, that's about $360 a month. I think it actually would be a little bit higher because the base support obligation would only be for 2 children, not 3. But at $360 a month from July to present, It's right around $6,000. I believe at the most, it would be looking at the amount in our proposed order initially of 16,000. But there absolutely should be, at the minimum, based on the amount set, the base child support obligation for the children and mom's percentage be a arrearage, basically, for the amount she should have been paying once their son was no longer creating the offset to whatever point the court sets the new obligation amount based on the additional financial information. Mom, at the time she brought the motion in September, identified income of $25 an hour. She twice filed proposed child support worksheets based on that amount. In the new filing, which the worksheet was separated, her income went down because she's working a new job at $20 an hour with no indication as to why she's taking a job with less pay than she was at the time that she initially filed the pleadings. We ran our worksheet based on our client's actual income and the $25 an hour she indicated she worked, and came out to the support obligation a little over $1,000 a month. Again, I can go into sort of detail on each of those, but I realize you're going to just sit on the arrears, so I'll stop and give a moment there.
And the last judge said that amount was so high, that's why we're here today. And you keep bringing up the contempt and everything, and that was resolved 2 weeks ago. We're here for the child support. I do make $20 an hour. It was by no choice of mine. So
between
yeah.
September 20th of this year and today, you've been cut $5 an hour in pay.
Yes, I started a new job. I left my job on October 17th and started this new job November 6th. And my question is, like I said, I don't have an issue with, supporting our daughters, but when our son aged out, why didn't Chris ask for support? I mean, why do they get to go back now when I am the poorest I've ever been? I
can't give you legal advice, but that is something that the court can definitely consider. So are you at A&D Auto Sales?
Yes.
And you started that
November 6th. I guess that's the technical name. It's Allen Webb Auto Group.
Okay. So I do see the earnings statement that was submitted. So your calculation based on that new employment, Miss Olson, is the $34.67 a month. Is that correct?
What did you say? I'm sorry, you cut out.
$34.67 a month is what you're estimating your
yes,
your gross monthly income.
Yeah. Yes.
All right. And Mr. Baldwin, your client's gross monthly income is shown at, hold on here,
Gross
97.23.
23. Yes, Your Honor, and a net of 59.73. Based on his pay stub that was filed October 10th, showing his federal income taxes, Social Security, and mandatory professional dues. But also, I guess, Your Honor, I can respond briefly at least to one piece. I believe my client's declaration reflected he had attempted to go through child support enforcement to enforce the support after their son aged out. But because the child support order specifically stated the obligation on him and didn't account for a scenario where there was no longer the offsetting, they couldn't help without bringing it to court. What ended up happening was a letter was sent to try and negotiate a resolution, and in lieu of that, she filed her initial pleadings in court, and that's where we are today. As to,
he tried to go
Hold
in
on,
June.
Miss Olson, hold on.
As to income, I guess a couple of things are concerning. When we were in court, there was an objection filed to strike a pleading from Miss Olson that was filed October 30th because it was filed late in time. It wasn't considered for the hearing. We were set over to today so she could refile regarding her child support. Though it's not probably considered as something substantive for Miss Olson. On October 30th, Almost 2 weeks after she said she lost her job at $25 an hour, she had filed the child support worksheet showing her gross income at $4,000. And I do find that somewhat concerning. I point that out only because in her prior filings, she has been very scattershot in what she has my client's income as. Her initial motion for support had him at a gross of $14,000 a month. We filed with a gross of $97.23 off of his pay stub, resulting in the net of $59.73. Her filing on October 30th had his gross at $97.29, very close in line with what we had, and a net of $59.66. And her subsequent filings from the 27th of last week had his gross income $10,540, $1,000 more than her previous filing, and a monthly net of $7,700, and about $2,000 more than her prior filing had shown his net as. We believe that our income for our client is accurate, and the court should set his income based on our proposed gross and net. We certainly have concerns with her income. I will say that I think if the court were to take 40 hours a week at $20 an hour, the amount for her income as stated in her worksheet from the 27th with a gross of around $3,500 is relatively close, if not accurate, for a full-time job at $20 an hour. But given that her other filings subsequent to the identified loss of the employment shows $4,000 or $4,300, we'd ask the court to set her income at $4,000 gross and $3,400 net.
Okay, so I have a question. So, well, it's a statement and a question. So the reason why my first one was so high for the respondent is because he tells everyone that he makes $65 an hour. So I didn't know that his actual, that's none of my business what he makes, but that's what he, tells people is that he makes $65 an hour. And so I didn't really know that he made $60.81 until, I received those documentation from the papers. And so I left that I made that because things don't seem to be going my way anyhow. But then when the judge 2 weeks ago said for me to redo them, I redid them at what I am currently making. So it wasn't to be malicious or anything like that, or I make $20 an hour. And so she asked me to redo them because that's why we're here. We didn't rule on it 2 weeks ago because she said that his is substantially higher than mine. And we're supposed to be going off of gross. He works a ton of overtime, a ton of double time. That doesn't get counted. So I'm not sure why we get to flip flop that, his gross is this, but he only nets this. Do you want to see my net? Nobody's asking for my net. Like I said, I can barely make it to the grocery store.
Well, your net is provided on the worksheet. So your net is $29.17.
I understand that, but I'm saying it's like they want to act like he doesn't make 3 times more than me. And he's well off.
All right. So here's what I'm going to do. I'm going to adopt Miss Olson's 3467 as her gross. And I'm going to adopt, excuse me, I'm battling some yucks. I'm going to adopt, his gross at the 97.23. Which puts his net at 59.73 and her net at 29.17. And I know that standard calculation is going to be different than either one of you proposed. And I also know that there was a credit that, at least in Ms. Olson's proposed, that she assigned herself based on cell phone payment for one of the children. And I don't know if that's agreed that she pays that, and frankly don't know if it's appropriate for it to be part of the child support credits. It's something the court would consider if that's agreed upon.
And And I can say, Your Honor, it's not agreed for that to be a credit. We did also have in our proposed worksheet, my client's declaration, $1,200 additional income to her on my client's information in his declaration that 2 adult sons who reside with her pay $600 a month each in rent to her. I didn't see anything in her declaration refuting that. So that was part of the additional difference in our proposed worksheet from what her gross income was and her net being technically higher after deductions because of that additional income.
I do see that in other income on your October 10th proposed child support worksheet. Ms. Olson, do you receive supplemental income for rent from anyone?
So we split the bills 3 ways. I don't pocket that money. They help pay towards the PUD, towards our space rent. You know, they help pay the Wi-Fi because they all use it. So I'm not getting that extra. It all goes to bills. And the last judge 2 weeks ago said, I mean, I don't know why he keeps bringing this up. Like, I mean, that
because I need to know all the information, ma'am. Okay. It doesn't matter what the judge 2 weeks ago did. I'm the one deciding this right now. Okay. So if you that's all I need to know. So if you pocket it, then
yes,
$100,
I get
it.
$177 extra dollars from each of my sons a month.
So you do pocket some money. It doesn't all.
No, they give me $177 each. There's 2 of them and it all goes towards bills.
Okay.
Every single dollar of it.
Okay. All right. So I'm not gonna add that to her tally, Mr. Baldwin, and I'm also not gonna add the $100 mobile phone expense. So I don't know if we can run the worksheets based on those numbers. That's the support that the court would be ordering.
Okay. And effective what date, Your Honor?
At this point, I'm going to say effective November 1st. I'm going to reserve on arrearages. For trial. I think there's more information that the court needs to really make that decision. So I'm not gonna, so what that means, Ms. Olson, is I'm not ordering arrearages for you to pay any arrearages at this point. However, that means that once we get to trial, if they are wanting to ask the court for arrearages, then they would be free to argue for that, and you would be free to argue against that at that time. Okay. Do you want to set a presentation date?
Yes, Your Honor, if we could.
How long do you need for that? 1 weeks.
Are you on the docket on the 26th?
Unfortunately, I am. Yes.
So the 26th is the next time I would be here, Your Honor. So.
All right, Ms. Olson, are you available the 26th at 1 p.m.?
I mean, I believe so. I thought it was all over after today.
Well, all we need to do is enter the final order because I adopted some of your numbers and some of his numbers. So we have to kind of do a calculation. If I will say this, if Mr. Baldwin runs the orders, you agree with the orders and you sign them, give them to me, I'll sign them and we don't have to come back on the 26th. Is that fair? Okay.
Yes, thank you.
All right. So we'll set a presentation for the 26th that can be struck if the orders are agreed and entered ex parte. All right.
Thank you, Your Honor.
All right. This is a motion to address decision making, and I didn't ever receive a response from the respondent in this case. Ms. Bliss, did you ever receive a response?
I did, Your Honor, and I did have that noted on my docket to discuss with you today. I did see on Odyssey that his responsive pleadings never made it to the court file. He did provide my office a copy, hence my client's reply that was filed last week. But I did see that his materials did not make it to the file, so I was curious as to how Your Honor wanted to proceed today.
Well, good afternoon, Mr. Fuentes. Did you file your response with the court?
Yes, Judge. I did.
Do you recall when you did that?
Last Tuesday or last Wednesday.
So that would be November. Sorry.
I have my office receiving it on the 30th, so I imagine it was probably that day.
So
yeah, that was the day, the
29th,
30th, the same day.
Okay. So I wondered because I see a reply declaration, but I didn't see. Okay. Obviously, Mr. Fuentes, since you did reply, I would want to consider what you had to say, but I don't know what you had to say because it didn't make it into the court file. I don't know if the clerk is able to look to see if maybe it didn't get scanned in yet, or if there's some other, or if it just wasn't received. And I don't know. I frankly don't know if the clerk has sees things different in Odyssey than the court does.
I'm almost wondering, and not to speak out of turn, but I'm almost wondering if maybe it got turned away by the clerks just because the form that he put it on is not necessarily the appropriate form, and it may have been an outdated form, just my suspicion.
That's a good possibility because I'm not seeing it in the record, Your Honor, waiting for it to be scanned in. It's not entered at all.
And Miss, I think I have Kaylee Maxey in there. Miss Maxey, is there still a log from the clerk's office of that shows what's not filed and why?
If it's turned away at the counter, I don't believe there's a log because we normally tell them that they can fix it.
Fix it. Okay.
Purchase the cover sheet if it's the wrong format. Sometimes we receive documents back, and sometimes we don't.
Okay. Did they turn away your documents that you recall, Mr. Fuentes?
The documents. They took the documents.
Okay. Well,
I mean, Your Honor, his response was maybe a page and a half, so I don't have any objection given how long we've been here today. If you want to give him some leeway to just orally tell you, or if you want to read it prior to ruling, I'll defer to you.
Do you have a copy of what you filed, Mr. Fuentes?
I don't have it on me. It's in my car.
I can email it to you right now, Your Honor, if you'd like.
Sure, if you could do that. Okay, I've reviewed the response and the attached messages. I also have, as I stated, reviewed the reply declaration, even though I was a little confused initially. So I will start with you, Ms. Bliss. Thank you for your patience, everyone.
Of course, thank you, Judge. And for the record, Carly Bliss on behalf of the petitioner moving party, namely Candace Fuentes. Your Honor's read the file. It's a relatively brief motion, but the issue before the court today is for decision-making as it relates to extracurricular activities. My client provides for you in her initial declaration that she has attempted to sign both children up for various extracurricular activities. She's frequently met with silence, no, not on Mondays or Fridays. And she goes on to tell you that she's even attempted to make accommodations to provide all the transportation, to swap days, because historically Mr. Fuentes's residential time with the children are on those aforementioned dates, Mondays and Fridays. My client has gone every way that she can to get these children enrolled in these activities to no avail. That's what's prompting this motion before the court. My client proposed a simple, she can enroll the children in 2 activities per year. That's what she's proposing for the court today. She believes that that's going to be the easiest resolution to prevent us from having to continuously come back before the court anytime an activity is proposed. She goes on to further tell you that when she does wait for a response from Mr. Fuentes, if he ever does come around to making or an agreement with the proposed extracurricular activity, that oftentimes the timelines for signing these kiddos up has lapsed. So these kids are missing out on opportunities due to either the failure to come to an agreement or the failure to respond by Mr. Fuentes. My client is asking the court to make the order allowing her to enroll these kids in 2 activities per year. Alternatively, and what may be more appropriate is to include language that provides a specific timeline in which Mr. Fuentes needs to respond. And then if he, fails to do so, then my client is allowed to enroll these children. But my client's simply concerned with the kids missing out on opportunities simply because Mr. Fuentes is refusing to co-parent with her and come to an agreement on getting these kids enrolled in activities. That said, too, these aren't activities that are extremely costly. Frankly, most of these activities contained in my motion are activities that the children have been participating in already prior to this motion being filed. So there's no legitimate basis in my client's position as to why Mr. Fuentes just simply won't agree. So this motion was necessary. We did need to bring it before the court for some decision making, and we asked the court to approve of it today.
Great, thank you, Mr. Fuentes. If you have any comments or argument you'd like to make, now's the time.
My only comments is I never told her that they weren't allowed to play sports or anything like that. I've actually signed our son up for T-ball. He did play football. We both took him to practices. We both participated and went to the games. She did want to put him in wrestling. I wasn't on board with the wrestling at first because my son has ADHD now, and him and his sister fight all the time. I wasn't quite aware if he was going to get more aggressive with his sister, that and the other. I did some research, a lot of friends and stuff that I've read it is okay for them to do that. And so I wasn't opposed to it. So she signed him up for wrestling, but we didn't agree on it. So that, like, there's no conflict between our kids playing sports. I mean, I don't have an issue with them playing sports at all. I don't care if they played a sport every season and we both paid for it. That's not an issue. The issue is that we don't agree on everything, because I wanted my son to play basketball and I let her know. But the communication, like she says, it's not fair on both parts, or both sides. We're both just not communicating. It's not even like we don't even talk to each other. Like, we send emails and text messages back and forth, so they get misconstrued. So it sounds like, hey, I'm just going to tell you flat out, no. I asked for her to pick a day other than Monday, because Monday is my only day with my kids. And I feel like every time it's a sport issue, she wants to take that extra time away from me for my kids. And I want to spend it with my kids and not having to take them to a sport or whatever. And I would do it if it was on that day. And I told her that I will do that. I don't have a problem with that. But it seems like every time I try to get my point across, I'm in the wrong every single time. I can't make a decision for them. I can't agree with her, but because she doesn't want to. And other than that, I don't have anything else besides the fact that I want my kids to play sports. I didn't get a chance to when I was a kid because I has asthma. My parents didn't allow me to. I want my kids to do better in other things than I got to when I was a kid. I do like to go to my kids' sports. I did want my daughter to do dance, but she failed to sign her daughter up for the dance on a Tuesday, and it fell on a Monday. And I said, I can't guarantee you that I'm going to be taking them every single Monday to her dance. But at the same time, when before our divorce was finalized, I had Thursdays by temporary court orders, which I took my daughter every single dance. And during the divorce, the mandatory settlement, she took away my Thursdays. So she took my daughter to dance practice or the class. So I would just go when I could get a time off work. I would go to those dance classes, and I did take her to a recital. So I do want my daughter to participate in dance, but I don't feel that it's necessary for her to be putting them in something every single year until they're 18 years old, when they're going to choose what they want to do when they're older. And when they're a little older, they're going to be like, hey, maybe I don't want to play basketball this year. Maybe I want to do karate or something. And that's perfectly fine. So this case, to me, this case is just like, oh, I want to make the control, and that's what I want. And for me to not respond in time, I 100% apologize for that, because I don't think it was fair on my part to do that to you guys. And at the end of the day, I want us to agree on these things, but basketball versus wrestling, and that's what it is. And for it to come to court, I'm here. And that's all I have to say. Thank you, Judge.
I appreciate that, Mr. Fuentes. We just figured out what happened with your filing. I guess it was mailed back to you. I don't know if you've received it yet, but they failed to notice until after they went to file it that you didn't sign it. So if you want to sign it and get it back to the clerk's office, we can get it filed. So it's documented that you did reply. Okay.
Yes,
here's, I am sensitive to the fact that when one parent has limited time with the children, especially when it's in the evening during the week, and there's only a few hours, that the frustration that may come with having half of that, if not more than half of it, being taken up by transporting to and from activities and kind of only getting to observe from afar your child instead of actively interact with them and have family time with them, especially if it's one child doing one thing, another child potentially doing another, or one child then having to sit there while the other child does something. So I get the frustration. I also get Ms. Fuentes' frustration with not getting responses in a timely fashion. I feel like there's the best approach would be to frankly just set a deadline. So if there's a proposal from either parent or a child, I know that they're relatively young now, but I think kids can have opinions and comments about what they want to participate in, especially in extracurricular activities. And it does appear that both parents are willing to listen to those kids, like, hey, I don't want to play basketball, I want to do wrestling, or vice versa. It sounds like both parents are willing to listen to that child. So once we land on what it is, let's have a 72-hour timeline for a response from the other parent. And I would, it sounds to me like, based on both of Mr. Fuentes's comments, his declaration, as well as the information provided by Ms. Fuentes that there is some leeway for when some of these activities take place. If Mondays can be avoided, I think we should try to avoid. So if dance class, you can sign up for a Monday dance class or a Tuesday dance class or a Wednesday day. If that's how that works, especially for someone, this child is 3 or 4 years old. I think we should try to avoid Mondays if we can. I am hearing that dad will participate and take kids where they need to go if it does land on those dates. But if every Monday is dance class for daughter and not, and that takes up, half of his 3 or 4 hours with daughter that day, I can understand that being a frustration. So if we can try to avoid Mondays and set a 72-hour timeline for response, if we don't get a response within that 72 hours, then the parent's allowed to move forward with it. I'd ideally like to keep it joint because I think both parents want the same things for their kids to be able to participate in these things. Does sound like there was some disagreement about wrestling or some concerns about wrestling. I think those were well founded. But it doesn't seem like there's a disagreement anymore. So if he likes wrestling and wants to continue to do that, then great, we'll keep him enrolled in that. And I appreciate the suggestion Ms. Bliss came up with 2 activities a year. If we have, frankly, a young child that has a diagnosis such as he does, 2 activities a year may not be enough, or we may get to a point where it's way too much. So I'd rather not dictate that at this point, but I appreciate that. But I would ask for a 72-hour response time and to encourage the parties to continue to try to work together for these 2 kids. If you want to do a supplemental order, Ms. Bliss, to the parenting plan, I'm happy to sign off on that. And we can set a presentation date. Or if you think you can work with Mr. Fuentes to present that ex parte, that's fine as well.
I imagine, given your Honor's ruling, we'll likely be able to come to an agreement, but just for safekeepings, if we could just have a
Sure.
date. Is your 19th docket still open?
It will be, I'll put you on it and then I'm going to close it.
Okay. If that works for Mr. Fuentes, then let's snag that date.
Are you available the 19th at 1 p.m. if we need it? Yes.
Yes, ma'am.
Okay. So I'd ask Kaylee if you could add this matter to the 19th for presentation and then close that docket. And then Mr. Fuentes, if Ms. Bliss sends you an order that you agree with and you want to sign off on it, then I'm going to authorize Ms. Bliss to strike that hearing. So you don't need to show up on the 19th. If there's an order that you agree with, you can send it to me and I'll sign off on it and get it filed.
Noel McClain,
All right.
appearing on behalf of the
Good.
respondent.
Thank you,
All right. Good luck. Thank you.
Erin Winkles appearing on behalf of the petitioner, Rita White.
All right. I'm going to start off with questions. If that's okay with everyone. Doctor, I spelled his name wrong in my notes. So is it Dr. Wu?
Yes. Dr. Wu is the one, Dr. Blaine Tolby is the other.
Okay. Dr. Wu, one party is indicating that Dr. Wu has been the PCP for the last couple of years. The other party doesn't agree with that. Was anything filed that shows who the child has been seeing as their primary care physician?
Yes, we filed the healthcare records. I believe I can tell you the CP of this. I believe it was the 3rd from the last thing filed in Odyssey.
The 66 page?
Yeah, it's big.
Okay. And
I'm sorry, I don't. No, that's a sealed.
That looks.
The 66 page when it's a sealed financial source document. The only thing filed under sealed health item were the progress notes from Betty Hayes, and then one.
Oh, that's weird. I have the.
I don't think that we. Let me. I filed sealed. No, I just filed portions of Betty Hayes's notes.
Yeah, let me see. We must have filed them at one point because I have them in front of me. Let me see if they were filed earlier in this action, and that's why we didn't just refile them. And we can reserve on that if you need us to file those records.
Frankly, I'm going to thank Ms. McClain because I didn't see it, and if it was right there under my nose, I would have felt bad. But I didn't see that, and I just had that as a question. And then
And that's my fault. I thought those were healthcare records because I have them in front of me. So my bad. That's definitely on me.
Okay. And then
But I think that the records clearly show, and I assume council would agree, that the child has not seen Dr. Tolby in 2 years.
And I wouldn't be able to state that without actually having them to review in front of me. So that, again, my fault. I thought those were them. I believe that the child has been seeing Dr. Wu amongst others for the last about a year and a half, but was seeing Dr. Tolby initially for, I would not say it would be 2 years. I'd say it'd be probably a year of seeing Dr. Wu amongst other people in the practice, and Dr. Tolby before that.
okay. And then is there, something I read made me feel that Dr. Tolby, was he under subpoena from mom on this case?
Yeah. So yeah.
And
So
that's part of the reason why he's sort of, okay.
Yeah. So we subpoenaed Dr. Tolby, and after that, Dad said no more of Dr. Tolby.
Well, that's not quite correct. I believe that Dr. Tolby had also removed himself from the case because of the issues that were taking place.
And that's not correct, because I did subpoena him. He assumed he was still the doctor. So that's not correct. Dr. Tolby has no issue continuing to be the doctor for the child. He said it was up to the parents.
Of course, yeah. And my client has a concern because of Ms. White's individual meetings with Dr. Tolby without the child. And then the concerns as it relates to the documentation and information that had come out after the fact.
Okay. And then did one of the parties file, historically, has the child been claimed by either party? I know that there's some discussion about 2022. Was there a filing in 2021 by either party claiming the child?
They filed, Mr. filed jointly, but the parties hadn't been together in 2021 at all. Mr. filed jointly, did claim the child, and that then there was a tax amount due. Mr. got a court order to have my client pay for half of that. So in that case, they both essentially they both claimed, although my client then, part of this, and you'll notice in her declaration, my client claims that Dad specifically changed the tax withholdings so that he would get the full payment of that in income, and then Mom would be responsible for half of the tax on that income that he was essentially separate income. So that's an issue for trial, but really the parties, I guess, jointly did 2021, and then Dad did 2022, and Mom is asking for 2023.
So we had to actually file an order, and Judge Hahn ordered the parties to file jointly. If you take a look at Clerk's Paper 60, that is the taxes order that was entered, ordering the parties to file jointly for 2021. We had asked that my client be allowed to claim for 2022. Ms. White has signed the tax form, or IRS form 8332, to allow him to claim, but then they wouldn't sign an agreed order so that he could claim under the court orders. So right now, my client has not filed claiming Benjamin. He tried to file claiming his oldest child, who he can legitimately claim under another court order. And his taxes were rejected, being told that somebody else had claimed him as a dependent, or had claimed him jointly or a dependent, one of those ways, and that his taxes were denied. So at this point, I guess one of my objections is I don't think it's appropriate for our settlement communications to be disclosed to the court as far as proposed agreed orders. Council's included those as attachments, and I think that that's improper. But we are asking that the court enter an order so that my client can file claiming the child for 2022, so that he's not in violation of the existing child support order. As it relates to 2023, we're premature. I don't have any financial information for her. The court doesn't have any financial information for her for 2023. I don't have my client's year-end wage stubs because it's not the end of the year yet. So I think we're premature, and I would ask the court to reserve on that issue.
Okay. And
Your Honor, just so you're aware, my client has not claimed the child for 2022, so I'm not sure why his taxes were rejected. She hasn't filed yet. Her income is going to be the same throughout 2021, 2022, 2023, which is about $22,000 a year. So I'm not sure that it is premature, given that there is a tax filing penalty if you don't submit by a certain date. We're now in December. We're talking about April. We should probably get this resolved so that the parties can talk to their accountants, give the documentation that's going to be here in 31 days. All of the W-2s are coming out. I'm sorry, my client just informed me she did file 2022 without the child. So she did file that, but the child was not included. So I'm not sure why his got kicked back. She, again, has no issue with him claiming in 2022, but she didn't want to state anything about 2023. And she felt that it was appropriate, since he obviously has now received a benefit this year and will have received a benefit the other year, 2021, given that they didn't live together, given that he received a $3,000 benefit on his tax, what would have been his tax liability, it seems appropriate that she get the benefit in 2023.
And again, I think that that's premature because we don't have her financial information. As counsel indicated or corrected, she did file in 2022. If you take a look at that sealed financial source document, the concerns that I have relative to the fact that my client's taxes were kicked back and rejected by the IRS is the second page. So it's actually the fifth page of her sealed financial source filing, which is actually the first page of 2022 taxes. You'll note that the second line actually has my client's social security number, but it doesn't have my client's name. And the next page identifies my client's, it says spouse's occupation as a biologist. So it appears, at least in some respect, that might have been considered as a joint. I don't know. There's no logical reason why my client's 2022 tax return should have been rejected. And if my client doesn't owe taxes, which he should have been entitled to a refund by claiming his oldest child and now has lost the use of that refund, there is no tax penalty.
Okay. I do see that. I didn't notice it when I reviewed initially. Spousal social security number, it doesn't indicate. So it obviously it's married filing separately is what was checked. It says if you check the MFS box, enter the name of your spouse, it doesn't tell you to enter anything else. And I don't see, so that the social security number under if joint return, spousal social security number, and on page 2, the information regarding spouse's occupation, phone number, that could be sufficient to muck up the works a bit, for lack of a better term. So I don't know, and I don't know if there was a request for a refiling by Mr. for Mrs. But if the child, sounds like there's an agreement that dad claims child for 2022, I have no reason to not go along with that. I'm a little concerned why his is being rejected, and I don't know if those two things, and Ms. Winkles, if you want to address those two things, if that could potentially be, an honest error on her part.
Yeah. So it is an honest error. So if it says on there, if it's a joint return, you have to list their first name and last name. And then if you go to the second page sign here, it says, if it's a joint return, both parties must sign. So he didn't sign and she didn't list his name. I think she thought she still had to include that it was him. She did call the tax authority and was told to put that down. However, I can have her go and speak to her accountant and see if that would be a reason it would be messed up. We don't believe it is because she did get tax advice before filing this. So I'm kind of shocked that his was rejected for that. Now the IRS will give you reasons for the rejection. I'm not sure if dad's aware of that or if he's gotten those reasons. It could be any number of things.
It was that he was claimed as a dependent.
He was claimed as a dependent. Oh, because here he's definitely not been claimed as a dependent. You can see on her first page, it says dependents, see instructions, and you'll see that nobody's been claimed there. So I'm not sure who claimed him, but it was not my client.
So obviously she self-prepared. She's an accountant. So she self-prepared this. It might be beneficial for her to get a transcript from the IRS so we can see what's happened. She can make that request online, but it's exceedingly frustrating that we have her having signed the 8332 so that my client could claim for 2022, and we have to be in court to get a court order for him to be able to do that without violating the child support order.
There is another issue though. He filed his, if you notice, at 9 a.m. and she filed hers at 12:18 the same day. So it could not have been rejected because hers was filed because he filed before hers. And you can see that at the error message.
In whose error message?
In his error message, it says that if you look at the time of filing, you can see on the e-receipt, e-file, congrats, it's been accepted. You can see that his was filed, let's see, that is Rita filed hers at 12:18. It's the page with the efile.com from eFile. And then if you look at his was filed at 9 a.m. on the same day. So his was filed first. It's the one that's filed under seal.
All right. Well, so, I would ask if Miss White can inquire of the IRS if his social security number and employment that's listed on her return could have impacted his return, and it was erroneously taken as him being a dependent of Mrs. White's in the filing. Beyond that, I don't know. I guess it's frankly a little terrifying to think that it would be just a random mistake that someone just entered a name and a social security number and it happened to be a real person and they claimed somebody as a dependent. But so I'd ask that she look into that so we can get the 2022 taxes completed. I am going to reserve on 2023. I have a feeling we'll be back soon enough. As for the motion for what we're actually here for, the motion for clarification filed by Ms. Winkles, I have reviewed everything. Any additional comments or argument you want to make there?
So we're here on the motion for clarification and the motion for the passport and the attorney fees. Clarification on the doctors, again, not asking if Dr. Wu has been the doctor that's been the child seen more often, that appears fine. However, because it's the way that practice works is it's whoever's available. And so the child's obviously seen a number of providers. If mom wants to have child see Dr. Tolby on her time, it makes sense. If dad wants Dr. Wu to see, that's on his time. That makes sense as well. Dad has been the one to schedule the appointments for the last year. And dad chooses, obviously who the child sees. The child does have a skin condition, eczema, and Dr. Tolby is a specialist in that area. You'll see on his resume. That's why my client wanted him to see that Dr. Tolby was namely for the child's skin issues. Dr. Wu's not saying anything about him. He's an excellent doctor as well. My client's happy with him. She has no issues with the child seeing Dr. Wu as well. If dad is concerned that Dr. Tolby might have some sort of bias because of any meetings, it can be, obviously, if mom is the one taking the child on her time to see Dr. Tolby, then Dr. Tolby would have no interactions with dad. And dad would be seeing, having the child see Dr. Wu. The practice itself runs on, again, it's like whoever's available you see. If your honor wants to set who the primary is for, non-timely issues, so not like a eczema flare-up, but just a well child visit, that's fine. My client has no issues with that.
So taking that issue, Ms. McLean, any response there?
Yes, and again, I guess just the lens in which Dr. Tolby has been interjected within this case makes it difficult. He's drafted declarations about his opinions of my client's character, and which my client takes exception with, particularly since they're in there such a short period of time, and he clearly has a bias towards mom, given her individual appointments with him, which are, we believe, focused towards this litigation. The child has had a continuity of care with Dr. Wu. Continuity of care is appropriate. There's nothing that indicates that Dr. Wu can't handle eczema. If eczema is an issue, then they should refer out to a dermatologist, as that's something that is regularly handled by a dermatologist. So we believe, first off, again, this is a joint decision. I disagree with counsel that they schedule with various providers. That's only on emergent issues. When we're talking about routine issues for this child, he can maintain a continuity of care, which should be foremost for this child. I mean, we all as adults have continuous doctors and a continuity of care, and there's benefit to having that.
Okay. It sounds as though there is an agreement that Dr. Wu has been primarily the individual seeing the child for at least the last year. And I understand, when you have a doctor's office with, say, 3 or 4 doctors, sometimes there is a shuffling around. I think it's probably barring any emergent, appointment where you're trying to get in to see somebody as quickly as possible. I think Dr. Wu should remain the primary care physician for the child at this point.
Unless the parties can agree otherwise.
Unless there's an agreement otherwise, if there's a switching of insurances or offices, if there's agreement otherwise, great. And obviously, I would hope that the parties would work together if there's a more emergent issue, like not an urgent care or an emergency room issue, and the only doctor that's available is Dr. Tolby to address an issue in a short turnaround, that the parties would work together for that, so to address any issues of that nature. But as far as planning and well child visits and all that should be Dr. Wu. the clarification, the second portion was, hold on, let me go back here.
It was on the video or the visits, telephonic contact.
Yes, and we're
I guess I would tell you that technically that was not part of the motion. I know that there's sort of this
it's on
declaration vomit.
It's the motion for clarification. It's on page 4 of 6, number B, letter B. The respondent has unilaterally stopped video visits. It's on that one, and then it says proposed language in order for clarification. It has that as the second one on the page on page 5 of 6.
Okay, and I was going off of the actual motion itself.
It is the motion. It's the motion for clarification.
Okay. We are dealing with, and this is another question for everybody. And of course my Odyssey is now loading, so I'm trying to scroll through this to get to the temporary plan that's in place, and it's going to take me longer than I was hoping.
That's clerk's paper 26.
All right, there we go. From November 16th, 2021, we have a week 1, father Monday 5:30, Wednesday father 5:30, mother Wednesday 5:30 p.m. to Friday 5:30, father Friday to Monday, and rotating. So it's kind of dad gets the first part of the week, mother gets the latter part of the week, and then first part, latter part, and then the weekends alternate.
The child's 3, I believe, as well. Just so your honor is aware. I think that kind of.
I guess my first blush impression of this is that I think it's important to have access and communication with your child, but we're not talking about extended lengths of time between visitations. So the idea, to be very frank, the idea that mom believes she should be entitled to a video visit every single day that she's not with the child, I think I don't think that's well founded in what we've got going on here. And I understand that's not specifically what her request is, but and I understand your position is that video visits have been eliminated and it's only phone visits. The parenting plan, now I have to go back to it because.
And just so your honor's aware,
paragraph 14F.
It wasn't for the short visits, the 2, 2, 3. It was only the longer visits that we were interested in the video contact. So not like an every day when they're transferring every 2 or 3
What
days.
longer visits are you talking about?
The summer, winter and holiday schedule.
Okay, well, that's not consistent with the facts as far as what she's been doing. She's been demanding basically daily visits. And also we've had this issue with her speaking in Portuguese. Of course, my client doesn't speak Portuguese. And when the child starts crying, he's wanting to know why the child is crying. And so quite frankly, our position is that she should not talk in Portuguese during these phone visits if it's upsetting him. My client should have a right to know what's being said to his child that's upsetting him. But I agree with the court that these are short visits. The demand that she has to have an everyday, visit with this child is intrusive, and it speaks of sort of an unhealthy relationship that she has with him.
And your honor, if we can argue this the normal way, because I'm concerned about when I can speak and when I can't. The fact is that summer they get 2 weeks in a row. And that's what my client's concerned with. The fact that my client speaks her native language to the child and it concerns dad because he can't understand, dad's not supposed to be there for those calls. The child is sad when he gets off the phone because he's getting off the phone with a parent. He's 3 years old. Mom isn't saying anything to the child. The fact that dad needs this control is evident throughout the entire case. That's the problem here. Dad needs to be in control of everything. And the fact that dad doesn't speak Portuguese has been a problem. And to stop my client from speaking her native language to her child is frankly, it's xenophobic, but more than that is it limits her ability to communicate with her child, which is not what the court wants to do. If the court wants to limit the no video calls during this 2, 2, 3 schedule, that's absolutely fine. But this is a 3-year-old child that then goes 14 days without seeing mom or seeing dad. That's a long time for a 3-year-old. And so for my client to be able to see the child at some point during that 14 days on a video call, speaking in her home language to the child that is bilingual, I'm not sure what the problem is for that. It takes her several days to even get a call during those times. Eric will not, or Mr. White will not facilitate them. We would love to get a set schedule for those longer times, maybe once every 3 days. something of that nature. But to limit her ability to speak the language she speaks, it seems frankly really controlling.
Hold on. First, Ms. Winkles, there's nothing in your motion that says that you're talking about holidays and summer breaks. So it just says that they've stopped allowing me to video chat and I want all this stuff. So that's why I asked the question that I asked, and that's how it started. So I think it's probably appropriate if these folks are not getting along and having some issues that we do set a time frame for holidays and summer breaks. If they're, I do think it's important for a child that age to have communication with a parent. And if there's a 2-week period, and I don't.
And just so the court knows, my client did allow a video visit when they were in Hawaii. She could see the palm trees in the back. She already knew that the child was going there. So again, the suggestion, well, I'll leave it at that.
And Your Honor, the reason I didn't bring it up is because the way the order states now is it just says the parent shall have liberal telephone contact with the child without the interference of the residential parent. That's it. It's such an open thing for parties that have so many issues. And I wasn't in the case when that was entered, but that works for parents that get along. It doesn't necessarily work for parents that are kind of at each other. Like this case is high conflict.
My client would prefer it wasn't high conflict.
So here's the deal. I do see that the 2 weeks on, 2 weeks off, essentially summer schedule, and the rotation changes a bit even in odd years. So I think that setup seems good. I do think it's fair. And I'm just going to ask that there be either a change, an addendum, an amended parenting plan that allow for video chat between the non-custodial parent during the holidays and breaks every 3 days, a minimum. So, and during that 3-week time, that would mean there'd be a minimum of 4 and, potentially more visits. Additionally, if the child requests it, I know this child's only 3 at this point, but a couple years from now, if the child requests it, that should always be granted. And I think the order already provides for that. The language I do agree with Ms. Winkles. The language is a little interesting I'm looking at F under the temporary parenting plan. I think interference is a concern, and I understand mom's concern there with interference. But I also understand that leaving a 3-year-old alone in a room with a telephone probably isn't necessarily the best setup either. So I want there to be no interference. So dad's girlfriend, significant other shouldn't be tickling, playing with, trying to engage the child while the child's on a phone call with mom, nor should dad. The child can be within sight line of the parent that's, while the child's on the phone. And frankly, as the child ages, interest in those phone calls is probably going to vary. I mean, let's be frank. Sometimes we think, the older they get, the more they're going to want to be on the phone. I don't know that arguably is true. But I think those should be child-directed phone calls. If child's engaged and it's a 20-minute phone call, great. If child isn't engaged and it's a 5-minute phone call, okay. So I don't expect anybody to leave anyone alone in a room or leave a child alone in a room, but I don't want interference from any party with the phone call. The concern with the child getting upset, I think if the child becomes upset during any phone conversations, and there is an intervention by the parent because of, I would agree with, I guess it was Mr.'s declaration that it's probably unreasonable to just, I'm going to leave the kid in the room crying. So at that point, if the child becomes upset and there's intervention, that there can be an inquiry of what happened, why is our child upset?
And why don't we just end the phone?
And I would object to that because I think that my client's saying the child's never upset and dad's saying the child's always upset. So now we have this, unless they want to record the calls.
Well, and here's what we're doing. There can be an inquiry. That's fine. That mom can say to dad, hey, what happened? Why is child upset? Dad can say to mom, hey, what happened? Why is the child's upset? I don't think there's anything wrong with that. If there's a disagreement beyond that, if the child's upset, I think, and no active communication can continue to be had between non-custodial parent at the time and child, then, phone call can be terminated at that point, but I think an inquiry is fine. I don't have, and I'm saying that simply because I don't think there's anything wrong with the mother speaking her native language with the child, especially if the child is understands that language. And frankly, it seems to be a benefit, especially with younger children, to learn foreign languages. It's the perfect time for them to do so. It'll encourage. I think it's just an overall healthy thing for a child to be bilingual, especially starting at an early age. So I'm not going to say that she's not allowed to speak Portuguese to her son or their son. I am going to, though, require her to, if there is a situation where the child becomes upset by something and she's speaking to the child in Portuguese, if dad wants to say, well, hey, clue me in what the issue is, dad, she needs to provide that information and not say it's none of your business. So we need to cooperate. I know that there's frustration between the parties, but you have this little person that is going to be drastically impacted by how much you do or don't cooperate with one another in raising him. The more that you can cooperate and try to work together for that individual, as much as you may dislike each other, the better off that he'll be moving forward. So hopefully that answers that question.
Yep. Thank you.
And international travel and the passport.
Yes, Your Honor. On the international travel, so originally this was put, just a little bit of background, I'm sure you've read it all. My client obviously wanted to take the child to Brazil when her mother was about to pass away. Dad said no. There was an order in the court saying that no passport further, unless there's a further court order or absent agreement. At that time, COVID was going on. There's an argument about what the doctors wanted at that point, but in any event, my client had to go to Brazil without the child. The child never met my client's mother. My client's mother passed away. Her dad's birthday, I believe he's turning 74, is April 3rd. My client would like to go and take the child to Brazil from March 22nd to April 7th. Her father, it's over spring break. She, wants to go have the child see the father. She's offered for Mr. White to come with her. He declined that. She has every intention of coming back. My client's life is here. My client has not lived in Brazil for almost 20 years. So there's no reason for her to move back. But her father is aged. Her father is ill. And her father doesn't have the money, and the embassy for Brazil to even get, or the US embassy allowing for that travel, is about 500 days out. And that's if my client can sponsor him, because of the type of country it is. She has to have enough money to sponsor him. She makes $22K a year. She'll never have the type of money that you have to have in the bank in order to sponsor him to come. Her mother died 2 years ago. Dad is really big about his family having this bond and connection with the child. My client just wants to have the child know his other roots, and to essentially know that country. Dad has no reason for saying that she can't take him. There has to be a valid substantial fear, and that fear has to be reasonable. Dad's entire reason before was COVID. That's what he stated. That was in his declaration. That fear has now passed. COVID is not an issue. While there is still COVID, most of us have immunity now that we can get over it. Dad has no good reason. Saying that mom is going to kidnap the child and leave is not a good reason either. And the reason for that is because RCW 2609-191 is where we look at whether or not we place a restriction on travel. And I've cited a bunch of case law in my memorandum, for your honor, but that is where the court has to decide whether or not there's a threshold and whether or not there's a danger to the child and if it should go under there. And here we have nothing that states that mom is going to be a danger. If you look at the factors that the court has put out in other cases about when you look for whether or not a parent is likely to abduct, you have these factors, and it's on page 7 of my memorandum where I list them. Mom has none of these. Mom lives here. Mom has a house. You'll see from mom's declarations from other people, mom clearly has friends. She's trying to buy a house. She is trying to get some education so she can be practice here. She's an accountant in the UK. She's not able to practice here as an accountant because you need to have degrees that she doesn't have, or classes that she doesn't have. She's hoping to get those. Mom has debt here. You'll see from her bank records. Mom has, income spent here. Mom was very close to dad's mother at one point. The fact is, mom has good friends. One of them even offered to put up a bond. Mom has no desire to go back and live in Brazil. So we haven't met any of those factors that are on page 7. And the court has to find that it has to be a particularized finding of harm before the restriction can be imposed on international travel. And it has to be where danger of damage actually exists. And otherwise, it's an abuse of discretion. And To say that mom is going to kidnap the child just because she's from Brazil is again xenophobic. The fact is that Brazil is part of the Hague Convention. Brazil has limitations on child kidnapping. Mom will buy a round trip ticket. Mom has offered Mr. White to go. Mr. White knows where client's mom lives, or client's dad lives. There are just no factors for abduction in this case. There are, aside from this court hearing, which is, costing both of the parties money, aside from that, there's nothing that would state that mom has this, that suddenly she's going to commit a horrible crime when she has absolutely no history of that. Did she try to get the child a passport at one point? Yes. And dad says, well, this is proof. No, this is proof that the parties were arguing and the court had not made a decision yet. This is proof that Mr. Again, as my client states, there's coercive control here. You'll see, Betty Hayes, that narcissistic tendencies. My client states that, he's brought other women in now that are watching the child. The fact is that my client did this as a reaction, but she didn't take the child out. The court had not made a ruling yet. And my client has maintained, there are other ways to get to Brazil. My client's not doing any of those. You don't see her taking the kid in the car and driving to Mexico and then driving through Mexico and getting a flight there. You don't see any of that because my client has no intention of not coming back. My client left Brazil for a reason. She does not plan on going back. We ask that you allow her to go have her child meet the grandpa. She'll be back on April 7th. We attempted to find a bond. Washington does not do travel bonds. My client hopefully will have a house here soon. If she can find a way to get funding, but it appears the house is cheaper than the rent is. But if my client's father dies without seeing the child as well, not having in-person contact, that means that this child has absolutely no connection to my client's family. She's brought over here, kicked out of the house in 11 months. She can't leave. She's here. And now we're saying that her family doesn't even get to know the child. And that's unfair. And frankly, there's no findings that this court can make that state that she's a danger, because she isn't. She hasn't done anything to even allude to the fact that she would do something contrary to a court order and a crime, and a massive crime. It's a felony. And especially since they're a member of the Hague Convention, Brazil is, it would be appropriate for that restriction to end and my client to be allowed to go visit her father on his birthday with his grandson.
A couple questions. You indicated Washington does not do travel bonds?
They do not. No, we tried. We called, I don't know, probably 50 different places. They do not. Washington State does not recognize the travel bond. My client did offer to put $10,000 into she'd have to borrow it into the court registry until she got back. I haven't spoken to her about that recently because I think that idea was cut down. But if that's what the court wants, we can make that happen. And my client did not try to get, I guess, a passport. She only got information from the embassy, just so you're aware, the Brazilian one.
Okay. And then the second question, and I'm going to start with Ms. Winkles, but I obviously if Ms. McLean has input, she wants to weigh in on, this in more to assuage any concerns, I guess, would, and I could be misremembering, but does the Hague Convention care if it's a temporary order versus a permanent order?
No.
Does that cause any additional hurdles or issues? For some reason in my brain, I'm thinking that it may, but
no. So the difference between the temporary and the final order is the amount of time you have to wait before you can engage it. So if you look at let's say it might be in my declaration or my memorandum, the temporary orders, you have to go back to your